Good morning. I would ask bailiff to please call if there's anyone here for the bond forfeiture docket.
There should be.
There shouldn't be.
There should be. Yeah.
Okay,
Chris is gonna show up this morning.
okay.
Anyone's ready, but this is second bond forfeiture document.
Chris,
Morning.
morning, Judge.
How are you, sir?
Pretty good. I haven't seen Tom yet, Kelly. That's what I'm waiting on.
Oh, is he coming as well? Okay. All right, let's hold it for just a minute until Mr. Kelly gets here.
Thank you.
Thanks. You want to see if he's on his way and remembers that, would you mind, please? All right, if I call your name, please come forward. Cameron Gutierrez. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez, did you get someone hired?
No, ma'am, I got the list of them.
Who'd you talk to?
Walker, Hall, Crenshaw, Rennick, Bailey, James, Wilkerson, Holmes, and J.D. Hill.
You talked to all of those?
Yes, ma'am. And
Hang on a second.
two of them I didn't
Listen,
talk to.
who'd you not talk to?
It was B. Holmes. She was on vacation when I called her, and another one I was waiting. J.D. Hill didn't call me back.
Okay, because he's a DA now.
Okay.
That's why I was asking.
Yes, ma'am.
So you actually talked to the
Yes,
others?
ma'am. I did speak to the rest.
And so where are you on being able to get someone hired?
I'm not gonna be able to.
Are you working?
Yes, ma'am.
Where are you working?
At all code,
And is that full-time?
full-time, yes, ma'am.
Okay, and what's your hours?
Monday through Saturday from 7 to 5,
And what's your hourly rate, wage?
$21.
I don't know that you're gonna qualify for a court-appointed lawyer. I'm gonna, I'll have you fill out some paperwork this morning. You need to fill it out accurately and completely. You're gonna swear under oath that it's all true and correct. So put any income, any bills, and then I'll take a look at it and see where you stand, okay?
Yes.
If you'll step in front of the clerk, she'll give you that paperwork. Yes, ma'am. Thank you. Bart Thibodeau. Bart Thibodeau.
Mark Thibodeau.
Okay. You know why my camera keeps getting moved? I'm all crooked.
No response from
This bond will be forfeited for non-appearance and reset at 100,000. Daryl Albritton. Good morning.
Hey.
You're Daryl Albritton?
Yes, ma'am.
And Mr. Albritton, did you get someone hired?
I'm still working on it. They kind of expensive because I had to pay for my daughter's funeral, so.
You could, I'm sorry, I can't understand.
I said they kind of expensive, so I'm still working on it because I just paid my daughter's funeral.
Okay,
Passed my daughter,
right.
so,
And you're working still?
yeah, I'm working the plant.
All right, who'd you talk to? Which
All
lawyers?
these people right here.
Just tell me which ones they are.
Walt, Wender, Corey, Crenshaw, Buddy. Yeah, I talked to some more on the phone. Them the ones I met in person.
Okay. So what I'll do, and I know you went through that with your daughter, I'm gonna reset your case about 30 more days to give you some time to try to get someone.
Quick question, the attorney you gave me, he said he gotta redo all my paperwork, so I have to rehire him or something.
So you were appointed Mr. Lewis when you were in
Yeah.
custody, but once you bond out, I expect you to hire your own lawyer. You've got a job, so you're making, so you need to try to hire your own lawyer. You're welcome to talk to Mr. Lewis about hiring him. He's still technically your court-appointed lawyer, but I expect you to try to hire someone before that next court date. If it's not gonna work out with the ones that you've already talked to at least 3 others. You can tell they all charge, and it's all very different. Bring me those names. If for some reason you don't get someone hired, let me know who else you've talked to and we'll discuss your options, okay? Thank you. If you'll step in front of the clerk. Roderick Anders. Roderick Anders.
Roderick, Anders, Roderick, Anders. No response, Judge?
Bond will be forfeited for non-appearance and reset at 100,000. Brianna Clannon. Good morning. Are you Brianna Clannon? Answer out loud so I can hear you. How old are you? You're 20. Next time wear something more appropriate to court. Okay? Do you agree that that's probably not something appropriate to wear to felony court?
Yeah.
I tested you this morning. You gonna have anything in your system?
No.
Have a seat in the jury box. We're gonna get you drug tested. Gerald Jackson. It's like I don't want to say anything. I'm scared. Good morning. Are you Gerald Jackson? Mr. Jackson, were you able to get someone hired?
I was hiring Nolan in Bronx, but he told me that he's no longer gonna do Beaumont.
Oh,
So
okay.
he referred me to, Dustin Galmore.
Uh-huh.
And I was gonna hire him.
Okay.
Process, but he's charging me 8,500, so I gotta get 4,200 to be able to get it.
Right.
And I'm trying to get to
That point. Okay. All right. So your case is getting old and you've got 3 of them. So we've got to try to get something done. See if you can get him hired before the next court date. If you can, great. Bring him the reset notice. If not, talk to some others. See if there's someone else you can afford and hire. If you can't, then we'll discuss your options at the next court date.
Yes, ma'am.
All right. Step in front of the clerk. Shay Morgan. Good morning, ma'am. You're Shay Morgan?
Yes, ma'am.
Did you get someone hired, Miss Morgan?
I actually had the funds to hire somebody this morning. I got a call from an investigator on Friday, and my car was taken. So the investigator told me that it was not a real Geico agent, and he said he went for my account. So they,
Miss Morgan, you've had the most,
a mess,
I'm sorry?
a mess.
Well, yeah, it's a mess, but there's just a lot of issues that you're blaming on other people, and you've been coming here now for a long time.
No, I mean, I'm coming to ask to get a court appointed. I mean, or I can hire an attorney because I felt like my income wouldn't allow me to get an.
Are you working now? So what makes you think that if you're working, you would get a court-appointed attorney?
I'm just gonna have to resave the money. The whole reason I denied a court-appointed attorney was because I knew that I wouldn't qualify. So, basically my attorney they told me it was $10,000, so I had the money. And, I mean, I can show where they took it out of my account.
Where are you working?
I'm Lake Pool and Water,
I'm sorry?
Lake Pool and Water.
And what,
Eastland, Texas.
okay. And what are your hours?
I'm a finance manager, so it's just one of the places I work on.
I can't understand you.
9 to 7 usually. The dealership closes at 7.
Okay. And what, do you make an hourly rate or a salary?
No, my income, I started on the 8th and it was 8,300 a month.
Okay, you need to get a lawyer hired, and you need to try to get one hired before the next court date. If you're making $8,300 a month, you are not going to qualify. You've been coming for some time. This is your last reset. You need to find a way to get someone hired. No more excuses. Step in front of the clerk. She'll give you a reset notice. Lance Charbino. Good morning, sir. You're Lance Charbino?
Yes, ma'am.
And did you, were you able to get someone hired, Mr.
No,
Charbino?
I was not. I had called to 10 or 11 different ones, but I got the law office at James R. Macon, DC, then Roebuck, Thomas, and Adams, PLLC, William Marcus Wilkerson's attorney at law. I just started working last week,
Okay,
and I am going to make a couple more calls to them if I'm able to.
okay.
Be able to get me one hired.
Okay, sounds good. So thank you for doing what I asked you to do. I'll give you another 30-day reset. If you can try to get one of them or someone else hired, great, bring the reset notice to them. If not, just call some others, like you said, bring me those names so know you're still trying, and then we'll discuss your options. All right, step in front of the clerk. Yes, sir. Keandre Stevens.
You can't argue from them. I'm not gonna say what happened. Likewise, that's why they have like 32,000. I get 86. That's why you know that's every day. Then must be patient. Just to wait. Like now I'm getting it. All right, so issues there. Looking for somebody that wants something. You'll be David. I was, and you didn't come yesterday. The keys to mine force, wouldn't matter.
So what do y'all think? Let's move forward on the trial docket. What do you see? Say, everybody good with that? Just one nod I got out of the whole room. One nod and nothing, nothing other than all. Yeah. John. Cordell Howard.
Ready, hard.
Oh, Mr. Eckertson.
This is the one that I tried to get everybody together last week, and last time one detective was not available that interviewed the defendant, and this time the other detective who interviewed the defendant a different time is not available. So one way or the other, either, and he's not available. He's out of state on summer vacation until the end of the month.
Okay, so we're gonna reset that until next month. Okay.
And I would suggest the very first trial docket of July. I can get everybody together to try
How's that
this.
look, Al? Yeah, this one's actually, this is one of the older ones now.
Yeah, it
These
is.
didn't used to be the oldest, and now we're whittling all that stuff down, and it's good.
I don't think I have anything.
All right, that's gonna be
We'll get it done.
first. Remember, we got July 4th coming up.
Right, the first.
What day of the week is that?
July 1st Friday, so.
So it'd be the
Okay, is that following Monday then, 7th?
In his email to us, he said he was back in July, and I know the other detective is back in July.
Okay. All right, well, on the 7th. What else? Great.
Their juries are tomorrow, so we'll have time to make sure we can answer them.
You're a main reader.
Good morning.
Hello, ready?
No, sir.
It's 1,127 days and you're not ready?
Judge, I have a motion for production.
When? Okay.
He told me
That
about
was
this last
filed
week.
6/9.
He told me that he said,
1,200 days into this?
yes, sir.
I'm railing on, but why?
I recently found out, like in the last month, about this particular facility. I need the records. It is my duty, Your Honor, to obtain.
Well, I know, but it's 1,200 days old, Joe. I mean, I'm not, you're telling me on the day of the trial, and you just filed the darn thing in the ninth. I'm railing on, but I mean, it's.
We could just do like
1,100.
a 4-week reset or so.
That'd be
Make sure we get it
Another
done.
case,
Yes, sir.
basically said.
Bring it 5 weeks.
Is that gonna be the last time we're gonna need something?
Yes, that I know of.
Resend.
Thank you, Your Honor. Thank you, Mike.
Algero McQueen.
Ready on that, Judge?
I'm ready. After speaking with Mr. Laird this morning, anticipate this resolving itself. Mr. McQueen is not here this morning.
When are they getting here, Tommy?
Sir?
The guys, when are the guys getting here?
Uh.
Like McQueen, for example, Algero.
We can, I can get it to him and try to get him here as quick as possible, but.
Well, they're all, yeah, we got, all. But they're on their way.
Yes.
Okay.
In the event that it doesn't, Judge, I'm gonna be at the federal courthouse this afternoon, so if the court could give me some leeway in picking the jury this afternoon.
Okay.
So we're ready on that one, just unless he pleads.
Okay, what's the odds in Las Vegas on that one disposing?
Can't give the court numbers, Judge. Just after speaking with Mr. Laird,
Well, it's probable, is that what you're hinting at?
possible.
Possible. Well, it starts with a P.
Well, I suppose if you were reading an injury report, it's plain, doubtful, questionable, out. Somewhere between questionable and
Okay, that's it. The important thing is we're all certain about it. That's what
clear as mud, Judge.
Isaiah Brewer.
File a motion to dismiss that. That's co-defendant Mr. McQueen. Attorney was here, or she went back as we talked.
She's right here, Jim.
Oh, there it is.
This says Mark Sparks.
It's Monique.
Oh, it's Monique.
Good morning.
I just knew Mark.
Should take it out.
While you're here, we're gonna sign this thing so you know it's been done.
Make you look real good.
But we could always have a trial if you really,
You know.
the rules of evidence are always enjoyable to.
You too. I'll watch it on my way home.
When you're driving, like,
Yes.
Well, the evidence gonna look out there, maybe read that, we'll see. I doubt it, but we'll see.
Okay. Okay.
So hold your breath.
I will hold it. You're not playing.
Anything can happen with these witnesses.
The police on the jail.
I've just dismissed Isaiah Brewer, 22-40057. So you're a big fan of that YouTube thing. I've never watched YouTube. I don't watch it. I hear about it, but I've got this thought though, if you're a big fan of that, how about this, one day? We're about to start the trial docket, but first, an important message from Monique Spones. If you need an attorney,
That's not. Check it. Thank you, Judge.
I haven't sold sponsors, but.
Got your buzzword.
Oh,
Let me know if you need a good catch for your.
Joe, we're back on
Xavier.
Xavier Senegal.
Judge, Mr. Senegal's filed a grievance. I've re-urged my motion with withdrawal. But other than that, we're ready.
I'm ready, Judge.
You want your liquid.
Well, so.
I do have a copy of that letter he sent to the court where he admits part of the conduct. So that's not something.
Been very good. Beyond my good.
I deleted it.
Whatever happened in 2013? Well, do you even remember any of that? What he's referring to?
I don't. I think he's mistaken, but I certainly don't remember any. This is the case of his next door. And I think
Just transferred over because Judge West represented him before. Really?
Wow. He's never been.
Okay. The, what's they say on this? Yeah, the problem in these types of situations is that anybody could say this. We open the door for everybody, and everybody in there could, class on how to change lawyers
Yes, sir.
until the end of time and never get your case. And
As a former defense lawyer, I've been in Mr. Vasquez's position before.
Right.
Actually, I try cases with grievances pending against me, so I know how this goes.
It's actually like a kitty grievance. They decide whether.
Well, you can't open a door just for one. Everybody gets to walk through that same door, and then people catch on pretty quick. And there's nothing in this notice that reflects anything inappropriate in Mr. Vasquez's actions. It's just a disagreement by the defendant. But he
They do encourage him to appeal then, or find a ground. I just felt I had your acknowledgement from the children.
but there's nothing in here that's substantive. It's just he didn't like it the way it's going, which who does back there? I'm not sure that this one is the one that I'll spend a lot of time today. Okay.
Yes.
But it needs,
Did you talk to me?
it needs something to be done. And I've got the other fires. Leroy Holden Jr. Leroy Holden, blank slate.
Hey, Judge, if you would hold on that, can I hold that one until they get him?
They're not in yet?
No,
Still in? Okay.
They're still not here yet.
Kenesha Hawkins, you got it.
So far.
Mr. Reynolds? What are we gonna do? Kenesha?
Got an offer, Judge.
You just need to wait for them to get here?
Well, I don't know if the offer's changed. If it's the same, then it's gonna be a trial. There's no ratings.
Be a trial. I have to get some doctors from Children's Hospital and haven't been able to get a good schedule for them to come judge. So I need one reset on it. I think this is the first time it's come up to trial with you and I.
McQueen though is ready, right?
Yes, sir.
If
Yeah.
they're not ready, Judge, can she get a bond? Also,
She doesn't have a bond?
well, some need, no.
Oh, okay, that's a bond.
Yeah,
I mean,
this
which-
is a 5-month-old that's been killed and second baby, and we have been ready in the past, just can't get the schedule with the doctors this time, so. We can have a quick reset if
The problem we
if he's
also
really
have is we got a murder case that's older, but I mean, I can set it as number 2, but Algero McQueen is 1, especially
Right,
Joshua Mendez, Mr. Buffalo.
We're ready, let's call it, Judge.
If he gets here, well, if he gets here to speak, then I went up to talk to him Friday. And he was supposed to call me, but he'd been in custody, so I just wanted to check this morning, but.
Anything new? Is that right? What's new?
He's just visited about the final offer.
Okay.
This case, Judge, I've got a GDNA witness that's already scheduled in 3 different courts. I don't think I can get her here this week. I've already been in I can show you my email chain with the different counties. She's doing Fort Bend, Jasper, and one other county, and we were 4th on the list, so if we don't work it out, I'm gonna need a reset.
Why are we so far down the list of counties? I
Well,
thought we
one of
were
those-
the best county. I thought we'd been number 1.
Fort Bend, who she's needed on Wednesday, is on the capital.
Are you agreeing on all this?
I advised him about the conflicts,
Oh,
Judge.
I know the conflict.
I'm trying,
Could you turn the?
Stand by. Okay, let's see. Danielle Davis, Langston?
Good, I think. Your Honor, that's the one where the co-defendant pleaded to 45 years last week.
And I believe we'd asked, we were preparing to go on that one. I know Mr. Adams was, counting on us preparing.
What is this one?
If we could reset it a few weeks, I think we can get it worked out now that the co-defendant has pled on it. And
When they get here, you'll talk to them. Is that what you?
Yes, sir.
Joshua Gothay? Joshua Gothay.
Yes, sir. Could I have a few minutes to talk to Mr. Pam on that?
Leo Cover is pro se. Ahmad Johnson?
I have that one.
Yeah, that's yours, Langston.
So, I'll give him one more shot when he gets in the job.
Okay. Trevante Nichols.
Yes, it was. Oh, Mr. Nichols, I'm not ready on him this in addition.
Daniel Boyd?
Let's continue.
On Trevante Nichols. They're still working on some discovery, according to Martin. Is that
we have some, jail calls, recent jail calls that may get this resolved. We'll see.
okay? Well, let me know.
Once I get that, I think it may change.
Jonathan Cruz. And, well, no, we're holding, these are, yeah, things are held up because.
But on this, we're waiting on a response from Enterprise on a subpoena for additional records that hadn't been turned over to the state. Sonny and I discussed.
They gave me this information, just recently, and it may result in a dismissal if what they're saying is true. So I would suggest we reset it.
All right, reset 4 weeks, okay? That ought to give enough time for everybody to figure if we're fishing or cutting bait. Chauncey Miller, Langston? Langston?
Chauncey Miller?
Yeah. I think that's you, the last one on the document. So.
Oh, yeah, okay. Let me,
When they get here?
when they get in.
All right, so we're waiting on the inmates to get here and things may or may not change. So. Stand by. Let's go with the 9:30 docket and see what's ready to go. Langston?
Yes.
Lindsay Maynard.
Yes, he has been evaluated already, I believe. Let me get him out of the
place. Well, you're not sure he's been evaluated? You want to get him out here?
No, he has been.
Oh.
He's been evaluated.
What are we gonna, what's an announcement?
He is adamant that he does not want any big deal. It's none.
Please, present them. That done it? May 30th is what I have.
Yeah, I got his. I got it too. Performance report. Here he comes.
Here he comes. You're Lindsay Maynard.
Yes, sir.
In cause number 24 CR 1913, sir. Mr. Adams is here representing you, and you were charged with a third-degree felony of assault on EMS personnel, which, as you know, carries with it up to 10 years in prison if convicted. There is a recent report prepared by Dr. Edward Kahn upon examining the defendant, and this is dated May 30th, 2025. It's also one dated May 21st, 2025. And these are similar, based upon an evaluation on May 13th. And the defendant is declared competent by Dr. Ed Lapon. I am calling these courts exhibit number 1 in this court today's date. Any objections? No. This will be a part of the record. Sealed and
But it's been a while since I looked at it. Does it evaluate only competency?
take your days. And May 30th, Dr. Ed Lapon not only reaffirmed his earlier analysis of competence, but went into the issue of sanity or insanity. Did you think that's going to be? Questions. I think he thinks out there is going to be fine. But you got a copy of this May 30th report. I got this one. That's 21, yeah. And then Dr. Dupont went on to take up the issue of sanity or insanity on his 30th day report. That's it. I thought this one.
What's the good doctor's opinion about that second issue?
Okay. It's, we got this, some competing issues is that the defendant is brought to the hospital with what is reported as a drug overdose in an attempted suicide. And he wakes from sedation in disoriented state, and attempted to remove the breathing tube, kick the nurse who was trying to assist him, which is, I think, where the assault was.
Yes, sir.
His version is the defendant states he doesn't remember. His diagnosis is deliriums, which is now long resolved. Now, delirium in psychoanalysis is a state of mental confusion and reduced awareness characterized by sudden onset of symptoms consistent with confusion, disorientation, and difficulty thinking clearly. It is a serious but treatable condition characterized by sudden change of mental state, including confusion, disorientation, and reduced awareness. Any delirium is a serious disturbance in mental ability that results in confused thinking and reduced awareness of one's surroundings. And it is obvious in this case, the man was suffering from an obvious delirium. He goes on to state that the determination of sanity or insanity is the province of the trier of fact. And the problem we have here is we got some competing interests. He's suffering under what Dr. Edward Pond calls confusion, delirium, but it's from overdose of drugs, which is not an excuse. You can't overdose on drugs and then start claiming defenses. So
it sounds like he's
fact finder to make a decision on these competing interests. But I think everybody would see, can see if somebody is is misusing drugs and then is being treated and starts beating up the medical personnel. We got problems. Medical personnel to be protected, and there is the issue of the patient, if they are in a reasonable state of mental awareness. But if they are not, because of their volitional misuse of drugs, that's not a defense. That's for, I guess, a fact finder to listen and weigh and make a decision over. But you can't say I'm going to misuse drugs and then later harm personnel who are trying to treat you.
So
if that were allowed, I think most people would say who show up to treat or to take care of someone, and then they find out that this is a misuse of drugs, then why would they want to put themselves in harm's way? Because they can be harmed, and then there's no accountability for it. That's not, well, that it does not seem to be a social standard that we want to go down. People need to be treated when they're not well, but the treating authorities should not be left without any type of defense under law. And otherwise, people are going to, the ambulance aren't going to start showing up at locations if they find out that it's a drug overdose. It'll get out pretty quick. But they've got other things to do that are more important than So, no, that's what it states. And it's fact is for the fact finder. You want to go to the judge or the jury, that's your call, but it's a possible defense that can be raised, but it's not for, it's for the fact finder to decide, and he's competent otherwise. So set it for trial.
But have you been able to talk to him about the offer or?
Okay. Yeah, I'll give him the offer. The last offer we got was a cap of 8 years. I did give that to him, and
All right, you told it to him. It's his decision. It's set for trial, and we'll let a jury roll it out. And
He has a lengthy criminal history and is not probation eligible.
anything else? You understand where we are, sir?
Yes, the
Okay.
attorney said, yes.
All right. Anything else you want to answer? No, just
My top attorney was not notified that this was happening today, and I'm trying to get my attorney to call my power of attorney, my caretaker, to be here. I have traumatic brain injury and seizures. I've been in the hospital all day yesterday and tonight, and I was missing this court date last time because of having seizures in the hospital. But I need my caretaker here.
We'll subpoena those records.
okay. Anything else? It's set for trial. Thank you. Next is, let's.
Thank you.
Yes, sir. Don?
Yes.
Michael Aguiar?
yes, please need to bring
Come on up. Michael Aguiar, thank you. Did the inmates show up?
Not, I don't think so.
Some are here.
Are they walking over?
Like,
They can only bring like too many at a time because we don't have this large.
Okay.
ones.
Oh, okay.
They're usually it's like, they'll probably bring some.
All right. Sun's on.
You didn't do one of these, did you?
I do need this.
Come on up there. And
I'll need this.
24 CR 1875 is called the state of Texas versus Michael Ozzie Baltazar Aguiar, correct?
yes, sir.
She's going to need you over here, right over there to get your fingerprint. Thank you, sir.
Right, Con? Thank
Yes. All right, the defendant is present with his attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment as you proceed in summary?
Yes, sir.
Is it just paragraph 1?
Yes, sir. It's all that's needed, Judge.
Paragraph 1 states in this indictment, sir, that on or about July 23rd, 2024 in Jefferson County, Texas, you committed a third-degree felony of unlawful possession of a firearm by a previously convicted felon. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to assert guilty or not guilty? Are you pleading guilty voluntarily or is on your own free will and because you are guilty?
Yeah.
I show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney with the contents correct.
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, the state you are mentally competent to enter this guilty plea. It's really involuntary. You know what you've been charged with. The indictment's been read to you. You've read it. You're guilty of the crime charged in any lesser included offenses. You are giving up your rights to the jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is here. State so help you God. State's Exhibit 1 is part of the record. Without objection, pre-sentence report is waived.
Yes.
If nothing further, sir, I'm going to follow this agreement and find you are pleading guilty voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of a firearm by previously convicted felon. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years as the court finds you guilty beyond a reasonable doubt based upon the evidence here. You understand what has happened today, sir?
Yes, I'm just TDC.
You will be given credit for all time. Yeah, you've served in accordance with this case, as everybody does. But you know how much you've served. Okay, thank you. That is fine. Puente.
He speaks only Spanish, so we need to reset it to a good interpreter.
You don't speak English.
Barely.
Okay, it's gibberish. But I can understand it.
It's two languages.
Two languages. How much time?
Whenever she can get, I guess do 4 weeks, and whenever she can get somebody lined up.
Yeah.
Okay.
I just wasn't aware.
All right, then, a translator for Mr. Puente will be ordered, and we will reset this in 4 weeks if you can get them to get with him and Mr. Dusler so that they can interact with communications. All right, Joseph Lewis.
You don't brought out, it's going to go on the trial document.
Joseph Lewis, please tell me 2 cases. Oh. Ms. Puente. Lewis. Are you Joseph Lewis? That you? Yeah, speak out so she can hear you. Thank you. Speak, sir.
Oh, yes.
Yeah, there you go. Okay. You were charged here with 2 cases, 25 CR 374 and 494. 374 is a state jail felony of allegation of fraud on or about February 15, 2025. You was intentionally or knowingly using identifying information, that is credit card numbers and Lone Star account numbers without the consent of the rightful owner. A state jail felony, if convicted, carries with it up to 2 years in the state jail. Joseph Lewis. 25 CR 494 charges you here with more serious punishment range here. In paragraph 1, this alleges that on or about March 5th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of harassment of a public servant, which would carry with it up to 10 years in prison if convicted. But this has a second paragraph, which states that you were previously convicted of assault on a peace officer and punished in the convicted in the court next door, the 252nd District Court in 2023. So if you were found guilty of this 3rd-degree felony, it gets enhanced if that prior conviction is indeed valid. And thus you would be looking at a 2nd-degree felony, which is no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 would be assessed. If that prior conviction is true, you're not eligible for probation in either of these cases in front of a jury. About right? Correct. All right, what are we doing on this?
He wants to plead not guilty, yes, set for trial. He's asking that I be replaced if it isn't on the docket.
Okay, is that right, sir? That's what you want? Okay, there's no deals. We're going to go to trial. There are no deals. This was your chance, and I find good cause to replace Mr. Dusler. The next attorney on the trial docket deal will be brought forth, and we'll try that case there. Or no deals on this, and we'll tell that person, whoever we hire, it's going to be fast tracked. Get this to trial as soon as possible. Next, that is on Kenneth Wiley. Kenneth Willie, I mean.
Yes.
Well, I haven't seen this.
Is Charles Floyd, Mr. Floyd?
Sure.
Okay, we're going to call you up next on James Van Rock. Yes, sir. You're in the queue. Thanks. You know, he was declared competent.
Yes.
Yeah, okay, you got it. All right, Mr. Willie, that's you, sir? Okay. And cause number 23 CR 752, as you know, you're charged with 3rd-degree felony of escape. And that carries with it up to 10 years in prison. There's a prior conviction, it is alleged, here out of Newton County, Texas in 2000, which interestingly enough, you were convicted of the 1st-degree felony of escape.
Yes, sir.
And so this third degree felony and this prior conviction together will enhance to a second degree felony punishment. So you're looking at up to 20 years in prison here. And you're obviously anxious for a speedy trial. You wrote something to me. You want a speedy trial. And certainly we'll do the best we can do to get, we tried 600 cases here. So we're doing as fast as we can. So anything changed other than?
No, sir. He'd like to be set for trial and have me replaced and get the court.
All right, then I find it, yeah.
Is there any possible way I can get it out where you just, I'll sign for 10 if it's ranked concurrent with the orange that I'm doing right now?
Well, I'm not the guy that you deal with.
That's the offers that's been made, Judge. It says that's been, I've offered 10 years.
Yeah, we can do it. Okay, so we're doing it. That's what I was trying to do. Yeah, right. But is there any possible way I can get the escape lower so I don't do the?
That's
pretty possible.
That's pretty all. But there's the offer that they're making.
That's what it is, but I'm not changing the offer.
And it would run concurrent.
Okay, so
But I mean, unless there's something happens with the other jurisdictions, but I don't have a problem.
Yeah.
All right, let me know when you're ready. Thank you. James Van Wright. Yes, sir. Looks like we got 2 cases here, James, on, I'm sorry, Mr. Floyd, on James Van Wright. James Van Wright.
He's not taking the deal. He's, if he doesn't pay for it. You gotta do this, it's your responsibility to get the pay.
Yeah, well, they'll help you. It's a good hand working. I'm sorry. Mr. Van Wright, is that you?
Yes, sir.
Okay, and you were here with Mr. Floyd, your attorney?
Yes, sir.
Spend.
So what are we gonna do? Yeah, we're moving this thing today?
We're gonna, he's
Okay.
gonna accept the week.
Okay, what is he gonna plead to both, or is one gonna be dismissed? What's the
The
plan?
offer is 10/10 probation, $500 fine on each case, Judge.
Okay.
Based on the mental health history, he'll be placed on the mental health case.
All right, we'll write it up and get the man out of here.
Sounds good.
Okay.
Thank you, Your Honor.
Thank you. Yeah. And David. Stand by.
He's in the shelter. He's in the step on.
I wasn't sure if he was still here. I didn't show that.
Stand back. Hold on. Hey, Donnie, what do you, I don't see your name on any of these lists.
Well, it won't be.
She's here as,
I'm not gonna be here on the bond hearing.
she's a domestic lawyer on my Trevor Burge case, Judge. She's observing the hearing where I'm seeking to increase his bond.
Okay, where are we? Where is Trevor Burge here?
It's at the end.
Oh, it's an add-on.
I think it was added on because it's a violation of bond conditions. I know.
Oh, Ms. Coffin?
I know he's here, Ms. Coffin's here, they're outside.
They're outside.
My victim's upstairs waiting for whenever
Okay.
we're gonna do that.
Try to get to it as soon as I can.
I'm good.
I regret I have but one body to give to my court.
Read all ordinance. So, good. Thank you for asking when I hear that.
You do me the honor, madam.
Done. So we're at your leisure on
David?
the judge.
Hey, David, Tardarian Parker.
He is a sensei.
Okay, we're ready?
Yes, sir.
All right. Tommy? Sure. Sure. Yeah, he's gonna be entering, please. Tardarian Parker, please. It was. He's leaving now? Yeah, but nobody likes being interested.
Well,
That's bad.
also the new drugs, and that right there.
Okay, we called, two cases here, 24 CR 1056 and 25 CR 491. The state of Texas versus Chardarian Parker, you and Mr. Parker, present with Mr. Grove, your attorney, and the state's attorney. The defendant has entered a plea of guilty to the aggravated robbery, correct?
Yes, sir.
24 CR 1056. And then this aggravated assault with a deadly weapon is to be dismissed as part of this agreement, correct?
Yes, Your Honor.
Is that right? That's what I understood. What was the date? 5/12. Gotta wait for her to get back. Earlier in this case, the defendant entered a plea of guilty to aggravated robbery. A pre-sentence report has been prepared. And have the parties had an opportunity to review it, and are there any corrections or changes? State
No, Your Honor.
and defense.
No, Your Honor.
I can't find Chardarian Parker's plea. It says the plea was entered on 5/12. There's nothing showing up on this screen. Can you pull it out and let me look at it real quick? Thank you. So if the agreement is a cap of 8 years in prison, what we're looking at is two options. No less than 2. No, stand by. It's a first degree felony, correct? No less than 5, no more than 8 years confinement in prison, or deferred or unadjudicated probation, which is an option. Regular probation is not available under the indictment, which alleges a deadly weapon, namely. All right, go ahead, Mr. Grove, you may go first.
Yes, Your Honor. Please, court.
Yes.
And looking at Mr. Parker's record in this particular case, I hate to say it, but he may be one of the more fortunate people, even though he is charged with and has pled guilty to an aggravated robbery in which there were 3 individuals that went into a convenience store, and Mr. Parker had a handgun. There were no shooting. No one was really, in fact, even pointed the gun at them, but it's a very serious offense. And we look back at Mr. Parker's criminal history. The first thing that I see in looking at his entire criminal history and other background is he is probably one of the few individuals that I have ever seen in front of this court that does not have any drug charges, convictions, or probations, which is very unusual as the court knows. And I think that it's something though that will help Mr. Parker as he goes on with his life, in that he doesn't use drugs. What he is, the other thing in this case, look at the age of the 3 defendants. Mr. Parker has no prior adult convictions. He has actually two probations as a misdemeanor, or juvenile rather, but no drug charges and nothing like that. He also almost made it through high school. He dropped out when he was in the 12th grade But this sets him up, and he's planning, if the court allows him, to go back and get not just a GED, but a high school diploma from his high school. And that's worth, in my experience, a whole lot more than a GED. But because of the particular circumstances in this case, he can still do that. Now, that he shouldn't have done this, there's no doubt about that. But Mr. Parker realizes that he came close to just ruining his life forever. Mr. Parker has a lot of family members that are here today. He has his mother, his father, his stepfather, his grandparents are here. He has uncles, aunts, cousins, and a number of family members that are in the audience to show the court that he has family support in this case. This is not a case in which he was going to be left by himself if the court decides to grant him deferred adjudication probation. He also has learned from his incarceration time. He's been in jail for about 4 to 5 months, and has learned that you can't stay in jail and accomplish very much. If the court grants him this deferred adjudication, he plans to return to his mother's residence upon release. He also is one of the few people that, if he were granted deferred adjudication, that he has a job waiting for him. This is through his father, through his employment at the refineries. This is an opportunity, Judge, where I think the court saved Mr. Parker just before things got really bad. And I'm not justifying anything that he has done, because none of this is justified. However, considering that this occurred when it did, he was quickly arrested, and probably saved his life in more ways than one. He would ask the court, and we can go into more details, that he wants to address the court, to give him the final opportunity to receive deferred adjudication probation, realizing it's a very serious case, but this will basically save his life. He also has one child that he is going to be supporting, living with, as well as the mother. And the amount of family support that this young man has, I think, speaks very highly of his family, but is going to give him a chance to succeed in this case. And so, again, without going any further right now, I would ask the court to consider giving him one last chance for deferred adjudication probation.
How many chances has he had?
Judge, we can count. I believe he has three convictions, and one of them actually was dismissed, I believe, and there were probations. Now he had some other arrests. I'm not saying he does not, but looking at the number of times he has been in trouble as a juvenile, he has no TDC. He does have what I believe is 2 probations, and then as an adult, he's currently on 1-year community supervision for evading detention out of Harris County, and I believe that is the only thing besides the pending cases.
Well, Judge, there's
Hold on. Are you through?
Yes, sir.
Okay, go ahead. Say.
There's just one hitch in all this, and that is that in the pre-sentence report, there shows an aggravated assault with a deadly weapon offense on February 5th, which was indicted recently and got assigned to me after this offer was made. And so he's accused of shooting someone. So there is another offense in which he's involved in that we did not discuss in the plea bargain in this case, because it got indicted after it came through the pike right as we were dealing with all this.
Yeah.
So he's got another second-degree offense where a man was shot in the neck. So
I would dispute that, Judge. I think we were aware of that, and I believe what the evidence shows, and I apologize to Mr. Laird. I don't mean to say anything about this, but I think we did talk about this. There were 4 people in a car. that approached another individual. A person was driving the car.
You're talking about this other case?
Yes, sir.
But this has been indicted?
Yes,
It's
sir.
been,
It's been indicted.
well, but it's
I
not
thought-
being dealt with today, right?
I don't know any other.
There isn't anything else?
There wasn't anything, as I know, the
Is that what
bargaining
we're gonna do?
agreement,
Is
I don't
this-
have anything written down that
You
says we
wanna
were
dispose-
disposed.
I thought we were disposing of that case.
No,
today.
this is the aggravated robbery.
Yes, sir.
Of
I mean, you can double check the
24
paperwork. I don't think
056.
there was anything dismissing it if we look at the plea papers. Huh? So there was one done? Okay, then I apologize, Judge. We'll
And
dismiss
again,
it.
that's the way I
Okay,
recall. it.
all right.
I will
Okay,
apologize.
we're just dealing with this matter.
Yeah,
Okay.
I just didn't have it's still an open case in my files. Okay,
He didn't sign.
okay. So,
I'm gonna sign it in a minute.
Okay.
If this disposal. Go ahead.
but otherwise, if he's done with his, I'll give my spiel on what I want on this case.
Go ahead.
Yes, sir.
Go ahead.
Judge, I'm looking at the story of the defendant. Kind of seems a silly excuse for showing a gun to a clerk, that he thought this was a joke. Looking at his prior history, with his chances looks like as a juvenile, he's had several chances of getting probation and getting himself straight. And then he's got the misdemeanors that he had. We would ask for the 8 years. So this is just ridiculous. Sticking a gun to anybody, especially store clerks. We have to protect them from people like this defendant, from placing them in danger, because guns can go off. Guns are intended for one thing and one thing only, and that is to kill. And so we would ask the court to give him the 8 years.
What would you like? Would you like to say anything, sir? If you want, this is your time. It's your life.
Yes, sir. I would like to say that I know I made a mistake, and I know that day that I wasn't thinking, but my intentions wasn't to hurt nobody or to scare anybody or to walk out the store with aggravated robbery. I know what I did was wrong, and it ain't nothing to justify what I did, and it ain't nothing to justify for me showing him the firearm and playing around with somebody like that. And I know that it was wrong, but I just want to learn from my mistakes and do right on probation, so I can beat up for my daughter, and beat up for my family, and go to work and go home and provide for my son, for my family.
Okay.
What have you learned about hanging around with people that are in trouble?
If I hang around people that get in trouble, I realize they get me in trouble. So that's why within 5 months of me being incarcerated, I realized that I can't hang around nobody unless it's my daughter or my family that's in the courtroom right now.
Yeah.
And you realize that if the judge is very lenient and decides to put you on deferred adjudication probation, but you could still end up doing life in prison.
Yes,
You
sir.
understand that?
Yes, sir.
If you screw up one time, depending on facts, the judge has that discretion to do that.
Yeah, so that takes a big part of it, and why I want to change for the better, because I know the circumstances of this case, and I know if you give me a chance, I know if there's anything that you could have did, and I just ask that if you give me probation, I can show probation that I could be better for the community, and see me in your court again.
How many times have you been placed on probation?
One time when I was 16, and one time when I was 12.
You're forgetting a few.
Then at age 17, I was placed on probation for misdemeanor out of tax county. So, the case.
Yeah, this juvenile, your juvenile history, you were placed on probation on March 23rd of 23 for 1 year delinquent court probation for unauthorized use of a motor vehicle. And then also on that date, you were placed on probation for evading arrest with a motor vehicle on March 23rd of 2023. Okay, that was a year before this crime was committed. Then while you were on probation for those juvenile cases, you pick up an evading arrest or detention in Harris County on November 28th of 2023. And then on July 1st, which was 3 months after you committed this crime, you're placed on deferred probation out of Harris County for that evading arrest and detention. Correct?
Yes, sir.
Then you've got this case you're dealing with. So in this pre-sentence report, God bless you. Yeah, when you talk to the probation office on a pre-sentence report, you have to be forthright and truthful. And I don't understand why people aren't truthful. They have everything to lose because all of this is written down. You state to the probation officer here, you entered the store with two friends, playfully showing the cashier an object resembling a firearm. And you ask the cashier, do you know what this is? The cashier expressed discomfort. Now, these are your words. The defendant, then you put the object away while laughing. And then people stole something, a few items, and took off. That's it. That's what you told the probation office after you looked me right in the eye and told me you committed this aggravated robbery. There it is right here. I am guilty. Well, you signed it. There's your signature right there. Right there. Remember, under oath, swearing to tell the truth. I am mentally competent. My plea is freely and voluntarily made. I read the indictment, discussed it with my attorney. I am guilty of the offense and any lesser included offenses. I swear all of this is true, so help me God. And you pleaded guilty to committing, while in the course of committing theft, intentionally and knowingly threatening or placing the victim in fear of bodily injury or death. And you knew you did then and there use and exhibit a deadly weapon, namely a firearm. That's what you pleaded guilty to under oath to me. But you go back after that and talk to the probation office with nothing to lose by telling the truth. And you say you're hedging as to whether you really used a weapon or not. You said it's something that resembled a firearm. But you had pleaded guilty to me under oath for aggravated robbery. Even at the end, you're not telling the truth. Even at the end, you can't be forthright. How can I trust you on probation when you're not forthright with us? You say one thing under oath and then you go back and say something else to the probation officer. It's hard to believe you. You're a grown up. Well, I hadn't been a grown up for long, but you're a grown up. You're an adult, correct? And you got responsibilities. You got a family, you got a child. Yeah. And yet, with the family at home that you're supposed to be taking care of, you're out with some other thugs robbing, using deadly weapons. The victim could have easily pulled out their own firearm and shot all of you. And they'd probably be given an award for doing the right thing and making the town better when they were threatened with their life. But when somebody takes a gun out and places a gun in front of somebody in their face, they think that's the last moment of their life. That's what they all tell me, that I'm no longer in power. I'm no longer in control of my life. Some stranger like you who doesn't have the right to do that is in control. And one stupid, foolish pull of the trigger is the only thing left between dying and living. That's not fair. That's not the way it's supposed to be. You knew better. You had important responsibilities at home. You've been through the system several times. You know, making mistakes has accountability. You're going to be held accountable in this. The fear people have and the waking up with the night sweats and nightmares the rest of their life, looking at a firearm and someone else is in control of their destiny, it's not right. It's not fair. And the law provides punishment for that. And you knew better. You had so many more important things to lose. And yet you made the choice to hang around bad guys and play with guns and threaten people with their life when you should have been at home. And you've been through the system. We've given you chances. You have made mistakes and you just have made an even worse mistake after being on probation for 2 or 3 places. I'm giving my spiel. I hate to see a person's life wasted, but each of us makes the choices. And That's what we have to live with, the choices we make. And you have family and probation, people who have helped you know better, and you still did an even worse act than before by threatening somebody's life and Stephen. And that carries with it, a crime like this carries with it up to life imprisonment. My goodness, that's how we treat it. It's important. It has the same punishment range as murder because it has serious consequences. Oh, here's what I'm going to do. I'm going to find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt in this offense of aggravated robbery with the use of a deadly weapon, namely a firearm. I am following this agreement. You were hereby sentenced. You were hereby found guilty beyond a reasonable doubt and sentenced, as I follow this agreement, to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. You will be given credit for term for time you have served, and the judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Do you understand what has happened today, sir? You have been held accountable for making a terrible mistake that you knew better. Now, we have one other case, correct? There is a motion to dismiss that case. And it's 24 CR 1056.
Yes.
Stand by.
Yeah.
It's 25 CR 491. 1056 is what the court just sent us the defendant to. The other case pending is hereby dismissed as part of this agreement. Do you understand what has happened today, sir? Speak. Okay. Good luck to you.
Is there some for any reason?
Abby, she.
Mm-hmm. Yep. Here, this one.
I can't really say.
Seriously, this one. Who is it, Don?
Willie, you just
come on up.
Minutes ago.
Mhm.
He's here signed up.
Now code 23 CR 752. The defendant is his attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment proceedings?
Yes.
In summary, this indictment alleges that on or about April 5th, 2022 in Jefferson County, Texas, you committed the third-degree felony of escape. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement?
Yes, sir.
And of course, there was that prior conviction that would have enhanced this up to 20 years in prison. If I follow this agreement of imprisonment of 10 years, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 110 in evidence without objection admitted. The state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer.
Yes, sir.
All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is what? I'm going to follow this agreement, sir. Nothing further. You were pleading guilty. I find voluntarily, knowingly, intelligently, you are mentally competent to do so. There's sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of escape. I now find you guilty of this third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice, serve a term of 10 years, as I find you guilty beyond a reasonable doubt based upon the evidence in this plea agreement and the plea papers here. Do you understand what has happened today? Yes. Good luck to you, sir. Thank you. That is all. Yeah.
What?
Which is, what, who's that again?
Charles, you ready?
Yes, sir.
Come on in. Thank you.
I'm gonna need a thumbprint.
Okay. James Van Ryan?
Van Ryan.
Yes, sir. And please see this lady. She's going to take a thumbprint. Thank you, sir. Hey, Mr. Blair, did the inmates ever get here on the?
They did just
trial?
about 5-10 minutes.
Oh,
ago.
okay.
I'm not Mr. Larry, but I'm the answer check.
Yeah. And instead of proposing or anything like that.
Right here, sir. Thank you. No, we call 2 cases. Two cases involving James Duke Van Wright. You are Mr. Van Wright. You have to speak out. So this lady, yes, sir. Okay. And you are here with your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? And Mr. Floyd is here representing you. And a couple of things first that we want to make sure that we deal with before we move forward. On April 8th, 2025, the defendant had earlier been deemed incompetent to stand trial, but was admitted to Rush State Hospital. After a period of observation and treatment, the defendant has been evaluated for competency, and it is of the opinion of the unit psychiatrist, Calvin Gerke, Gerke, Dr. Gerke of the Rush State Hospital, and Rush State Hospital Superintendent Michelle Foster. They have certified that the defendant is now competent to stand trial based upon this letter dated April 8th, 2025, and it will be made a part of the record in each case. Call that Exhibit 1. Without objection?
No objection.
Whatever call. Is he pleading in both cases or is one case to be dismissed? Both. All right, in these two cases, 36332 and 37946. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
Yes, sir.
Number one, 36332, we'll take them numerically. In this case, sir, it is alleged that you on or about June 1st, 2020 in Jefferson County, Texas, committed the third-degree felony of failing to comply with sex offender registration requirements. Do you understand what you're charged with in this case?
Yes, sir.
And in 2137946, it is alleged in paragraph 1 that on or about June 12, 2021, in Jefferson County, Texas, you committed the third-degree felony of injury to an elderly individual. Do you understand what you're charged with this? Okay. These are both third-degree felonies. They're not enhanced, right?
No, sir.
Okay. These are each third-degree felonies, which means you face a term of not more than 10 years or less than 2 years in prison and a fine of not to exceed $10,000 in each case. Do you understand the punishment ranges?
Yes, sir.
Agreements have been reached where you would be, in each case, the same. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for up to 10 years, fined $500, and there will be terms and conditions of probation, including you'd be placed on the mental caseload. Is that your understanding of the agreements?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand? Sir?
Yes, sir.
How do you plead in each of these, guilty or not guilty?
Guilt.
Are you pleading guilty voluntarily, that is on your own free will,
On my own free
and
will.
because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1, and he's got to sign the bottom of that. That's about the most important thing there. You did go over all of that with him, and
Yes.
he affirmatively agrees.
Yes, sir.
You sign them. Okay. I'm going to show you what's marked as State's Exhibit 1 there. Mr. Van Wright, did you sign that document, understand it, discuss it with your attorney in each case?
Yes, sir.
And is everything true, correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection is submitted.
No objection.
Stand by. Mr. Ham, at the bottom of this page.
Did I miss something, Judge?
Yeah.
I apologize.
That's okay.
Thank you, Your Honor.
Okay. And how do you plead to this failure to comply with sex offender registration requirement in 36332, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Same both. And in cause number 37946, injury to an elderly individual, that third-degree felony, how do you plead to that case, sir? Pleading guilty voluntarily and because you are guilty.
Yes, sir.
And that agreement states that you as well would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years and fined $500. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, in each case, you have no right of appeal.
Yes, sir.
And once again, State's Exhibit 1, in each case, did you sign those documents? Voluntarily, knowingly, intelligently, and discuss them with your attorney? Is everything true and correct? Correct? You have to speak out.
Yes.
Yeah, there you go.
Yes, sir.
State's Exhibit 1 in each case is tendered without objection,
No objection.
admitted. Among other things, in each case, this states you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer in each case. All true, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record in each case. Pre-sentence reports are waived.
Yes, sir.
All right. I'm going to follow these agreements, if nothing further, and I'm going to find in each of these cases, Mr. Van Wright, you were pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence in each of these cases from State's Exhibit 1 admitted in these hearings to support your guilty plea, to find you guilty beyond a reasonable doubt in each case. I now find you guilty beyond a reasonable doubt in each of these cases. I'm following these agreements. You are hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice to serve a term of 10 years in each case. Those terms of confinement are suspended. You will be placed on regular probation for 10 years in each case. You must pay a fine of $500 in each case. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be ordered to attend and complete anger management program, among other conditions of probation. Make sure you follow these. If you fail, your probations could be revoked and you could be sentenced up to 10 years in prison. Do you understand? We don't want that in each case, okay? Please see the probation officer. Thank you, sir.
Thank you, Judge.
Yes, sir.
Judge, my book.
Hold on, let me check. Make sure there's so many things that want signed here on this last one. Yeah, Mark. Uh-oh. What I did.
They got him over. I talked to him. On.
Here.
Yeah, thank you. And we've gotten the discovery. Then he was giving it to him. I'm gonna go review and then review.
Okay. Thanks. Let me know. Yes, sir. Brittany Holmes? Yeah, she is. Is it Edmund Latulis?
Yes, sir.
Come on up. 24 CR 1758.
Okay.
That wasn't even a good sneeze. That was,
Brittany. Yeah. Matilda? Yeah,
does he need to sign?
Yes, I need.
You need to
Oh,
fingerprint over there, sir. Thank you.
You two more safe phone, and you want to. Safe phone. You don't have to question. I'll read all of that. Thanks.
What is it?
Representation for.
Where is it? Yeah.
Do you do this?
What do you want to do?
Did you have there is the correct week? Yeah.
You know, he's got 1, 2, 3, 4, and looks like a 5th one, a new one.
I've got 5 cases.
You got all 5 solicitation as well?
Yes.
Got the new one.
Okay, he wants that, all those set for trial?
Yes, sir.
Done. Okay,
Thank you.
set those for trial. And Mr. Latulis.
Yes, sir.
Okay, 24 CR 17580 is called Edmund Gerard Latulis Jr. That's you. Present with your attorney, Ms. Holmes, and the state's attorney, Dust, the defendant. Waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about July 22nd, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of unlawfully possessing a firearm by a previously convicted felon. Being a previously convicted felon, do you understand what you're charged with here, sir? A 3rd-degree felony like this one means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? If an agreement's been reached, you would be sentenced to 7 years in prison to run concurrently with other cases. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead with this? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney. Are the contents true and correct? State's Exhibit 1 tendered into evidence without objection admitted. The state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer, all true at state, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report waived.
Yes, sir.
I will follow this agreement. If nothing further, I'll find you are pleading guilty voluntarily. You are mentally competent to do so. There is sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea, to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this 3rd-degree felony of unlawful possession of firearm by being a previously convicted felon. I'm following this agreement. You are hereby sentenced to confinement after I find you guilty beyond a reasonable doubt. Confinement to the Institutional Division of the Texas Department of Criminal Justice to serve a term of 7 years. You will be given credit, of course, for all time you have earned in accordance with this case. Do you understand what has happened today? Yes, sir. Good luck. Do better. Do better. Okay.
And you
I already got it.
Okay.
Thank you.
Raymond Fontenette.
It's a plea, Judge.
Raymond Fontenette. Is he in the back?
He is, Judge.
Okay.
This one, yeah. I do need his vote.
Leroy Holden off the trial docket. Do you have your trial docket with you? That's a plea. We got him signed up here in just a second. I think it's underneath.
Who was it?
Who is it? Holt Leroy?
Yeah. I think Mason's got him taken care of.
I've got 2. I'm just gonna sign them up. I got 2 off the trial.
Okay.
Doing it right now.
Stay
Hold on,
easy.
hold on. They go right here. So I'm talking, yeah, I got 2.
He ran. Okay.
All right.
Oh, Raymond Fontenette? That's you, sir? 25 CR 402 is called. You are here with your attorney, Ms. Manaldi, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about March 10th, 2025, in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with here, sir? If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you will be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there is no fine. There would be terms and conditions of probation that are normal and customary. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and on your own free will?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and fresh? State's Exhibit 1 tendered in without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All through, so help you God. State's Exhibit 1 is another part of the record for all purposes. Pre-sentence report is one. I'm going to follow this agreement and find if nothing further, you are pleading guilty voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty. State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in support of your guilty plea. And I can find you guilty, but I am going to follow this agreement and place you on deferred or unadjudicated probation. What do y'all say about the time? I know what they recommended is has been 7.
In this case, I don't support it, Judge. I mean, I understand they're asking for it, and I'm sure they've got a good reason. So if you want to, I understand, but I don't support it.
Stand by. Let me just look at that. The key thing here is criminal history, none, and then circumstances of the case. All right. Okay. This shows that all of this is occurring at 3:56 in the morning.
Yes.
Yes. Nothing good happens. 3:56 in the morning unless you're at work. Oh, in most cases. See, you drove the vehicle off-road through a vacant lot, then onto the roadway. Police activated their emergency systems, chased you. You evaded by fleeing westbound on North Street. Throughout the north end and south end of Beaumont, back on the north end, almost 15 minutes, disregarding, going through numerous red lights and stop signs. Why'd you stop? What happened? Took you that long to figure that out, did it? You exited and then you weren't through, you ran. They had to chase you down. And you had an outstanding warrant for your arrest at the time. Did you know that? What was it? What was the arrest?
Found out it was like a theft case.
A theft case. Okay. All right. Here's what we're gonna do. You're gonna be placed on probation for 10 years on this deferred or unadjudicated probation. But if you do well, it will be shortened to 1/3 of it. What's 1/3 of 10? 3 1/3. 3 1/3 years. That's 1/3 of 10, if you do well. Now, there will be terms and conditions of probation, not the least of which will be driver's education, among other things. And that help you make better choices. Plus, do you pay for your own insurance or is it somebody else's insurance? The vehicle, your miles. Well, you would be, if it's your insurance you're paying for, then you would get a deduction because of the driver's education. So it's a win-win here. And don't foul up. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 10 years in prison. Do you understand? Right. Did you learn a lesson here? What? Can you hear okay? You can. Everybody hold it down. Thank you.
First and foremost, not to go out of like 3 in the morning, around or after I have to tax that pick up things and all the one day. Second, not to get in any more trouble like this, not how to move anything, just the people who are there on here. Such things like that. Also around that jail is not legal.
You don't enjoy being in jail, do you? Good. I hate to hear you would. That'd be terrible. Be working against the whole master plan. This is a 4,000-pound missile. It's not a toy. We get people killed because of bad things happen when they're fleeing with a car. You're lucky. It could have been worse. All right. Please see the probation officer. Thank you. Matthew Smith.
He's a plea as well, Judge.
Matthew Smith, please.
I need Mr. Fontenot's thumbprint.
And we need Mr. Fontenot's thumbprint before he leaves. Matthew Smith. 24 CR 2405 is called. You are Matthew Allen Smith.
Yes, sir.
With Ms. Manali, your attorney and the state's attorney, does the defendant waive the formal reading of this indictment and arraignment? Can we proceed, sir?
Yes, Judge.
In summary, sir, this states that on October 27th, 2024, in Jefferson County, Texas, you committed the third-degree felony of injury to an elderly person. Do you understand what you're charged with in cause number 24 CR 2405?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Fine $500. Is that your understanding? And there would be terms and conditions of probation normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Yes. Are you pleading voluntarily and because you are guilty?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Would you sign that voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence without an objection admitted. The state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You wrote it. You were guilty of the crime charged in the any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your attorney. All true. So help you God. State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived.
Yes.
I'm going to follow this agreement and find you were pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any findings, place you on deferred or unadjudicated probation. For how much time? You're requesting the lucky 7.
Yes, that's correct.
What's?
I have no objections. Either he'll succeed in that time frame or not. It's the visualization of his increased judge.
Here, let me see.
Yes, sir.
Okay. This is the manuscript. You're over here. This your father? Is that your father? That's your father? You struck in this case? So you're not guilty of this?
Guilty, I guess, but I'm guilty.
The state you intentionally and knowingly caused bodily injury to your father, Greg Copeland, who was 65 years of age or older, by striking him in the head. Says in the head with your hand. Anyway, there he is, with a severe laceration to his face. What do you think of that? What do you think of that? This, what happened? What do you think?
Oh, yeah, he's my father and I love him.
Oh, you do? So quite naturally, you punch him in the face. Where is it in what's that part in the blessed 10 commandments? Honor thy father and thy mother. You didn't do it on this case, right? Did you? Did you?
Yeah.
Okay. I just can't imagine doing that. Punching out a parent. That's just ruthless. That's just mean. All right. I'm going to find it. Here, sir, you understand what you're charged with, and you were pleading guilty to this indictment of assault on an elderly person. You were doing this voluntarily, knowingly, intelligently, because all of this is true. State's Exhibit 1 has been admitted without objection. Here at this stage, you are mentally competent to enter this plea. It's freely and voluntarily made. You know what you've been charged with. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance of confrontation, cross-examination of witnesses. You are totally satisfied with the representations provided by your lawyer. All true, so help you God. State's Exhibit 1 is made a part of the record without objection.
Yes, sir.
Pre-sentence report is waived here. I'm going to follow this agreement and find you are pleading guilty voluntarily. You are mentally competent to do so. There's enough evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation which are normal and customary. Among other things, for this type of office, you will be required to complete an anger management course. There ought to be a course on respect of not only your elders, but honoring your parents. But we shouldn't have to have such a program that is inherent in the law and in all laws, spiritual and in man-made. You must pay a fine of $500. If you fail on probation, your probation could be revoked. You could be found guilty and then sentenced up to 10 years in prison. Do you understand, sir? Yes, sir. You don't treat anyone this way, especially an elderly person, especially your parent. Go see the probation office. I shouldn't even have to lecture you on that. That all goes without saying. Shame on you. Mitchell Sylvester. Mitchell Sylvester.
Just that, it's my problem.
Is he, do we need him out? Mitchell Sylvester, thank you. She's making an editorial comment. Scott, you're gonna be up next. What are we gonna do on Gilbert? Sir? Great. Okay, he's up next. Yes. After this one, this will be short. And then I'm gonna go finish the trial docket and finish that up. And then get back to the completion of this. Mitchell Sylvester? Come on up, Mr. Sylvester. Yeah. Over here. All right, 25 CR 307 is called Mitchell Joseph Sylvester. That's you. Present with your attorney, Ms. Minaldi, and the state's attorney. As you know, you're charged with this. Hello, I see a problem here. You're charged with the first-degree felony of aggravated robbery alleged to have occurred on or about February 16th, 2025 in Jefferson County, Texas, and the states that you used a deadly weapon, namely a machete, in the commission of this offense. You're facing, if convicted, no less than 5, no more than 99 years in prison, confinement in prison, or life imprisonment. However, it doesn't end there. I'm looking at 4 prior felony convictions dating back 45 years ago to 1980. Conviction in the court next door, the 252nd, for aggravated robbery on August 11th, 1980. After that was final, it is alleged that you then in March of 1988 committed the offense of illegal possession of a controlled substance, a second-degree felony, and in this court, I was just a child, you were found guilty of that offense and convicted. After that conviction was final, it is alleged that you committed another offense on July 8th, 1991, another illegal possession of a controlled substance, a second-degree felony, and you were convicted in the 252nd District Court of Jefferson County, Texas. After that one was final, it is alleged that you committed the felony of prohibited substance, having a prohibited substance in a correctional facility, a third-degree felony. You were convicted of that in 1996 in the 252nd District Court of Jefferson County, Texas. So you have been an habitual felon 3 times ago. So you are looking, if this was true, proven true, you were looking at no less than 25 years, no less than 25 years confinement in prison up to life in prison. Do you understand what you're looking at in the punishment range? All right, what are we doing today?
He's requesting his table.
Okay, well, did you want to put anything on the record?
Sure, Judge.
Go ahead.
So prior to this, we had an initial offer of 30 years PDC as a plea offer. You understand that? Is that right? She needs to take it down on the record. And then through negotiations, we have gotten that offer down to 20 years PDC. Is that correct? And I have relayed and talked to you about that offer. And then you understand that if we go to trial and reject that offer, that your minimum potential punishment is 25 years. And then it could go all the way up to 99 for life. And you're choosing to reject that 20-year offer that the prosecutor's offering.
Yes.
So she said.
And Your Honor, just to be clear, that offer was available for today, and that was just to get this, we were gonna move this case, but if we're setting it for trial, then I would stand with the 30-year offer that.
Yeah, ladies.
Yes, sir. Yes, sir.
Right to be heard.
Yes, sir, absolutely.
What do you want to do?
Sorry?
All right, get it done. You're making that decision voluntarily and after discussions with her, right?
Yeah.
Okay, well, get that then, when you're ready, let me know. Thank you. Gilberto Vega? Gilberto Vega, thank you. Two cases, I think, right?
Yes, you guys. I asked to grab all that stuff. And then it does look like.
We pleading to both or just one and dismissing?
Oh, Judge.
You rejected?
No, they're writing on.
Yes, follows. You know, that other guy you're gonna sit next to.
Oh, it's really more the administrative traffic.
That's in my computer though. My computer's battery may got dead. Good times, good times.
All right, sir. You were Gilberto Acosta Vega Jr.?
Yes, sir.
And you were present with your attorney, Mr. Rennick, and the state's attorney? Does the defendant waive formal readings in these two cases, 25 CR 476, aggravated assault with a deadly weapon, second degree felony, and burglary of a habitation?
Yes, sure.
A first degree felony?
Yes.
And can we proceed in summary?
Yes, sir.
In summary, 25 CR 476 alleges that on or about April 8th, both of these allege on or about April 8th, 2025 in Jefferson County, Texas. And in 476, it is alleged you committed the second degree felony of aggravated assault with a deadly weapon, namely a knife. And in 477, it is alleged you committed a first degree felony of burglary of a habitation with the intent to commit aggravated assault with a deadly weapon, and that's a first degree felony. You understand what you're charged with in each of these cases, sir? In 476, the second degree felony, you are facing, if convicted, a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. This will run concurrently with the next case 477. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in this case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
And we're gonna hold that one in suspense for just a moment. In 477, in summary, this alleges that also on or about April 8th, 2025, you committed a first-degree felony of burglary of a habitation with intent to commit the felony of aggravated assault with a deadly weapon, and you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here?
Yes, sir.
The agreement is the same. You would be placed as before. You'd be placed on deferred or unadjudicated probation for up to 10 years in length. Fined $500, and there would be terms and conditions of probation, which are normal and customary for this type of offenses. Is that your understanding of the plan?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead in each of these cases, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? Jimmy?
I'm sorry, Judge.
Yes, sir.
Okay. I show you what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 tendered in depth without objection. Each of these cases, sir, you were pleading, you are mentally competent to enter your guilty pleas. They are being made freely and voluntarily. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas in each of these cases to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty at this time. I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be fined $500. There will the victim in each of these cases, what was your relationship with her?
Girl.
And what's the status now? No relationship?
They're still communicating, Judge.
Do you see anything wrong in treating someone you care for this way? You don't see anything wrong? You do?
Yes, sir.
Oh. Are you accepting responsibility for your
Yes, sir.
poor behavior?
Wrong choice.
You care for this person?
Yes, sir. I do.
Of course, it begs the question, what are you capable of doing to someone you didn't like? If you're going to treat somebody like this, who you say you care for, it doesn't make any sense. You got to fix that. There will be terms and conditions of probation, and I'm the findings in each of these cases, even though there's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I'm placing you on deferred or unadjudicated probation for 10 years. And find $500 in each case. You will be ordered to complete anger management program and other terms and conditions of probation that infer also that you don't treat people like this, especially people you care for. And it's unfortunate that we have to have programs that we make people go to treat others decently, especially people who they claim they care for. That you should have ultimate, complete, selfless respect toward people you care for and others. If you fail to follow these terms and conditions of probation, your probations could be revoked. You could be found guilty, sentenced up to 20 years in prison in one case, and up to life imprisonment in another. It's a shame I have to threaten you with life imprisonment to make you show love for the person you say you love. That just doesn't, that should go without saying. You have a lot of making up to do. Treat the person decently, like they should be treated. Or do you promise to do that? Oh, good enough.
I need to get you first. You guys wait. You won't have to go.
Another one.
Okay, right now.
It's in bond.
Here.
I believe you have.
Name on it. Just say something. I didn't have to be saying that. If you want here, and we're going to do it again. Anywhere in the future. Okay. That's it. All right, then. Two more.
Here's,
Next one.
Mr. Sylvester. Okay, who do we have?
I got 3 off the trial back this week, 3.
Okay.
That's just, she's writing it.
Huh?
She's writing it.
Okay, hold on. Oh, who do you have?
I got, no.
Off the trial
I
docket?
have Mr. Ahmad Johnson. I have
Come on up,
Mr. Holman.
Mr. Johnson.
I
Thank
got
you.
Miss.
Can we do that female first? You don't mind?
Yeah. Who is this?
This is Miss Davis.
Okay, she's all signed up.
She's all signed up.
Danielle,
Come on, let me.
come on up. 2 cases, correct?
No,
It's just, they're gonna dismiss the.
They're gonna dismiss them?
All right, it says once she's pleading on the sexual case.
I have 2 cases here, cause numbers 23, a CR 889, the credit or debit card abuse, state jail felony. 23 CR 1491, the first degree felony of aggravated sexual assault of a child. Is that what she's pleading guilty to?
Yes, sir.
91. 889 will be dismissed as part of this agreement.
Yes,
Okay?
sir.
That's great. And are you Danielle Davis?
Yes, sir.
Here with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment in 1491? Can we proceed in summary?
Yes, sir.
In summary, ma'am, this indictment alleges that on or about December 1st, 2021 in Jefferson County, Texas, you committed the first degree felony of aggravated sexual assault of a child, which carries with it a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you're charged with and the punishment range applicable?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 17 years. Is that right?
Yes, sir.
Imprisonment. And then clause number 23 CR 889 will be dismissed as part of this agreement. Is this your understanding of the agreement? You will be given credit for all time you have served in custody in accordance with this case. If I follow this agreement, ma'am, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? I show you what's marked with State's Exhibit 1 there. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. The state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, cross-examination, confrontation of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes.
No objection.
Pre-sentence report is waived.
Yes, sir.
I will follow this agreement if nothing further and find you, ma'am, are pleading guilty voluntarily. to this first degree felony of aggravated sexual assault of a child, and it's aggravated for, among other reasons, the child was then and there younger than 14 years of age. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here admitted to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this first degree felony of aggravated sexual assault of a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 17 years. Do you understand what has happened today, ma'am?
Yes, sir.
Stand by. Now, one other item we need to go over. You now have a reportable conviction or adjudication for an offense requiring you to register in the sex offender registration program. And this is aggravated sexual assault under section 22.021 of the Texas Penal Code. And thus you are required to register. This is not completed yet. You've got you got to fill this out more. I'm going to help on the top. All right, I'm going to show you. I filled all of this. Is this review it? Is all of that correct? And did you sign that document? And yes, it is going to be part of the record. And this is a sex offender registration admonishment. So you now have a reportable conviction requiring you to comply with the Texas Code of Criminal Procedure Sex Offender Registration Program. Failing to do so properly and timely would be a criminal offense that can result in prosecution. If you move to another state that has similar reporting requirements for sex offenders, you must report and register in that state, and failing to register can result in you being charged with a criminal offense. Do you understand the requirements here? And I believe this is for life.
Yes, Your Honor, that's correct.
Of this, in this case, these requirements will last and follow you for the rest of your life. So make sure you follow them. Do you understand that?
Yeah.
Anything else on this?
No, Your Honor. Your Honor, and I did submit the dismissal on the state jail felony case.
Well, real quick. I don't have it. Do we have this, the dismissal?
I don't have.
That's going to be Commissioner CR 889, right?
That's correct.
Well, I should have.
Well, it always feels this every time I try to plug it in, it's bored over any time it goes, oh, just.
Okay, when it comes across, the court will sign a dismissal on 889 as part of this agreement. Next, who's next?
Mr. Jose.
Yeah.
Yes, ma'am.
I remember you took away my phone calls and stuff like that while I was in the county.
And I was on restriction. I couldn't get no type of communication whatsoever.
Yes, ma'am.
And I'm not gonna get in communication with her, and I'm just trying to find out if I can get my communication back. Like my postal mail and stuff like that.
We don't have any objection, Your Honor. The main purpose was that make sure the witness wasn't being influenced or anything like that.
Communication, attempt to influence the witness.
Yes, Your Honor.
I don't, I will lift that order, but whatever the jail, if the jail has other orders for other reasons, I'm not going to interfere with that.
Okay.
That's going to be their business. But as far as that order from me, this case is disposed of now, so it's no longer necessary. You need to live your life completely differently than harming children in this way. That's the most,
You do.
that's
Thank you.
most harm.
Appreciate you.
Anything else? That is all.
That's it. Later today.
Who's next?
Mr. Holden.
Mr. Holden? Leroy? I have two cases, correct?
One to be dismissed.
One will be.
Don't have to, we take what you're saying.
It's the assault family is the one that's gonna get this mix. I think I got that one, Mr. Sonny.
Twenty-two, 41127, assault, family violence, choking, and 23 CR 2182. State jail felony with illegal possession of a controlled substance. You are charged with each of these, and you are Leroy Holden Jr., correct? And you are here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of each of these indictments? Can we proceed in summary? Which one is he pleading to?
He's pleading to the
182?
Yes. Right.
The other one's going to be dismissed?
Yes, sir.
All right. In 182, sir, in summary, this alleges that on or about May 1st, 2023 in Jefferson County, Texas, you committed the state jail felony of illegal possession of a controlled substance, namely cocaine. Do you understand what you're charged with? If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Good.
An agreement's been reached where you would be pleading guilty, sentenced to 13 months?
13 months.
13 months in the state jail. And you'll be given credit for all time served. And as part of this agreement, 22-41127 will be dismissed. Is that your understanding of the agreement?
Good.
If I follow this, you have no right of appeal of your case. Do you understand?
Good.
How do you plead to this charge, sir? Guilty or not guilty?
Good.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yeah.
Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yeah.
State's Exhibit 1 tendered into evidence?
No.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. Is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were given your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. Made a part of the record purposes. Pre-sentence report is waived. I'm going to follow this agreement, if nothing further, and find Mr. Holden, you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of illegal possession of cocaine. I am following this agreement. You are hereby sentenced to confinement in the state jail for 13 months. Do you understand what has happened today, sir?
I'm submitting a dismissal in cause number 41127.
And 41127 shall be dismissed. Anything else?
That's it.
That is it. Thank you. Do you have one more?
Yes, sir. Mr. Ahmad. Jonathan.
Ahmad Johnson?
Yes, sir.
Twenty-three CR 2327 is now called the state of Texas versus Ahmad Leandrew Johnson. That's you? Present with Mr. Adams, your attorney, the state's attorney does the defendant. We have a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 1st, 2023 in Jefferson County, Texas, you committed the third-degree felony of indecency with a child by exposing your genitals. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 10 years of not more than 10 years, nor less than 2 years in prison. Also, a fine can be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You will be pleading guilty, and whatever sentence shall not exceed a cap of 5 years in prison. So we are looking at no less than 2, no more than 5 years confinement in prison. I guess deferred or unadjudicated probation from up to 10 years in length on a probation term where you would not be found guilty and placed on probation. And regular probation is not, as I understand, because of the nature of the case, is not an option. Is that correct, everybody?
Correct.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1 tendered them to evidence and without objection,
No objection.
it's admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states so.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Now, we need a pre-sentence report,
Yes.
and we'll come back at a later time after the report is completed. I will accept any other additional information. The lawyers will have an opportunity to argue their positions, and then the court will assess the sentence in this case. Does everybody understand?
Yes, sir.
Okay, anything else on this?
Yes.
Please see the probation officer. Thank you.
We can.
Mr. Johnson's phone.
Bond? Mhm. Any other pleas in the queue?
Off your trial docket, Judge. There's the Algeria McQueen. I think that's in your queue.
Hold on, hold on. You get all these from the.
We are kind of
Docket and.
needing that to get that sorted so we can figure out what the trial is.
Before us.
Right, it's been just. There it is. Sending it in.
Yes, ma'am.
That's her. It's signed as well. That's, I think, on the jail.
All right, finally, after a while here, let's get back to what's left on this trial docket so we know where we stand. Correct me if I'm wrong, we've got Al Jerome McQueen ready.
He signed up in the queue for plea, Judge.
And that's Mr. Kelly.
Yes, sir.
Come on up.
Thank you, Judge.
Let's get that done. 22-40058 is now called Al Jerome McQueen. That's you, sir.
Sure.
Present with your attorney, Mr. Kelly, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? And we proceed in summary.
We do, and yes, Judge.
In summary, this indictment alleges that on or about May 28th, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder. Do you understand what you're charged with?
Yes, sir.
And it is alleged that you shot the complainant with a deadly weapon, namely a firearm.
Yes, sir.
This is a first-degree felony, which means you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Sir.
An agreement has been reached. In your case, you would be pleading guilty, and whatever sentence shall not exceed a cap of 30 years in prison. So we are looking at really two areas here, no less than 5 nor more than 30 years confinement in prison. And also you could be placed on deferred or unadjudicated.
On murder, there's no,
that's not even there.
Yes, sir.
Smart. So then there's no regular probation available as well. So that's your options, is confinement in that length of time. And a fine up to $10,000, I think, can be assessed. Is that your understanding of what your punishment range is in this case? It's capped at 30 years. What we're going to do is get a pre-sentence report. And after you enter your plea here in a minute, I will order a pre-sentence report by the probation office. Please be full and forthright with them. They will prepare a background study of you. We'll bring you back here in a few weeks. Each side will get a chance to present any other information they want me to know so I can have as much of an informed and educated decision about your life as possible. And then I will make a decision after they make their arguments. Is that your understanding of what the plan will be?
Yes, sir.
All right. How do you plead in this case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Let me show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. All right, I'm going to order a pre-sentence report. We will all return back on
7/28.
September 28th.
7.
This is July. I thought you said September 7/28.
Oh, good for that.
July next month on July 28th, and all parties will have an opportunity to submit additional information and the court, and make arguments, and then the court will make its decision in the case. Anything else? That's all. Thank you.
Right. Straight up and down, don't roll. Give me two more things now. Same thought. Thank you. One more. You're not John, are you John?
Not yet.
We already took care of Mitchell Sylvester, didn't we?
No, I haven't signed up, Sylvester. Mitchell Sylvester.
Mitchell Sylvester, please.
Is that off the trial docket too?
No, I don't think it is. It's not on that's not on the trial document.
No, sir. No, you're
Okay. I'm gonna get to that in a minute.
Yes.
Let me go on the trial docket. I think we're have one. Okay, I have. And Isaiah Brewer in here.
That was dismissed.
That was dismissed. And it's that one. And Algerol McQueen has pleaded. I've got Xavier Senegal.
Mike was ready on that one, but Joel said there was a grievance filed against him.
It's all right, made this noise. That's okay.
Tanisha Hawkins,
That's the one that we have witnesses in Houston that we can't get here this week.
Joshua Mendez, as we said. Joshua Gothe.
I didn't get that far in my preparation last week, but I've identified 3 witnesses and we're going to try and round them up if we can.
David?
Joshua Gothe is in custody. He does not want to plead guilty.
Okay.
To the plea bargain offer that's
Okay.
been made.
All right. Leo Cover is pro se. Right?
Like it said, standby counsel, Judge.
Who is?
Right.
And he's on vacation. Yes. What about Devontae Nichols on Marvin?
That was Marvin said he was not ready.
That's the one, Your Honor. We did get some recent jail calls and that Mr. Lewis, I think it's going to resolve that case and Mr.
And
at that time.
Chauncey Miller.
It has to be someone.
Did Langston plead that one out?
Langston did not know that case was even on this docket. I don't remember what happened with it. Okay. Is he still back there? So
We can go back to that one, crossed it off, but
which one?
pro se. They had hired Ripe at one point and then did a motion to withdraw and released him, and he's supposed to say, we do not have a second counsel for him to stand by. If we did, it has to be someone we can appoint, you know, comes right.
Okay,
You just went by it real fast. He files motions every day. There's a whole lot.
okay, what were we doing on Senegal again?
That was the one that Joel said that he was filing, re-urging his motion to withdraw because of the grievance. You denied that today, I believe.
Denied
the motion to withdraw. Reasoning that if every defendant did that, then, you know, I don't know about Joshua Gothe's, my witnesses, because we were busy down here last week, but I've only got 3. They're all with the sheriff's office and I'm trying to round them up right now.
Well, what was our plan on Xavier Senegal? I've got an asterisk. That's still in the queue to go, right?
Yes, you were contemplating where you were going to order it, like what number you were going to order it. So I think right on the first page, it's between that and Joshua Gothe really at this point.
Okay, David?
Yes, sir.
If I'm gonna put Gothe first and Senegal second. Okay,
Yes, sir.
and let me know if those work out somehow.
We're working on rounding up those witnesses from the SL.
And then what was Chauncey Miller on Langston's?
Daniel went back there to find Langston, because Langston was supposed to be seeing if he could work that out or.
Okay, that's number 3.
Okay.
Chauncey Miller is 3. That's this. Hmm?
He's been writing every day.
Yeah, I'm so, okay.
Judge, Mr. Gothay, court talked to him, he may change his mind.
I'm not gonna. That's not for me to do.
I'm not telling you to do that, I'm just
Okay.
saying.
Okay, I will bring, but let's bring Gothay out, and so he'll, no, yeah.
Just on Miller, if you don't mind, that's the bottom of that. Can you just give us one reset on that?
No, it's gonna be number 3. If it gets to it, we gotta move it one way or the other, if we get to it.
All right, let me. So we know 3.
Yes, 3, but they're dropping like fleas.
Yeah. Let me see what I can do.
Then. Who do we have on Mr. Cover as a standby?
We have to.
Yeah, but Kindler's out of town, right?
That's something we can't appoint.
Let's
We're looking for the sheriff's office.
Let's get somebody else then stand by on it.
And I'm not sure, Your Honor, if he provided him with the discovery. I know. Maybe it had.
Okay, well.
But we have all of our witnesses, we're ready.
I know, but there's nobody there ready, is what we're saying on cover, right? We don't have a defense.
Right.
Ready.
Yes.
No, we just don't know what he's saying.
Right, he's pro se, I'm not sure. We've got all our.
Mr. Miller?
Let's go say.
Oh, let's go say. Sorry. You're Mr. Gothay?
Yes, sir.
Joshua Gothay?
Judge, this is a habitual case and the offer is 5 years. He is rejecting that offer again today is our understanding.
That's correct, Judge. The office is made 5 years.
I don't have the file. We have to give it to somebody. I made it faster to you.
He has credit for, I think, 635 days. So he would be very close to parole eligibility under the 5-year offer.
Stand on. Oh, there it is. Okay. Joshua Ray Gothay, is it Gothay? Goth. Yes, Goth. I knew some Gothays and then, and they pronounced it Gaucher too, some of them. But Goth. And, here, sir, you are charged, as you know, in 23 CR 1455 with, in paragraph 1, this 3rd-degree felony of evading arrest or detention with the use of a motor vehicle, which would carry with it no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. Paragraph 2 goes on to allege, I think you remember talking to you about this a while back, but paragraph 2 states that you were convicted in this court in 2007 of robbery, the 2nd-degree felony of robbery, which would mean, if that were true, you would not be eligible for probation if you were found guilty by a jury, in this case. Paragraph 3 goes on to state that after that robbery in 2007 was final, this states that you committed the felony of illegal possession of a controlled substance, a 2nd-degree felony, and were finally convicted of that offense in 2019 in the court next door, the 252nd District Court. So if all of this was found true beyond a reasonable doubt, you are looking at not just a third degree felony, but habitual felon status. You're looking at no less than 25 years up to life imprisonment. If all of this was proven true, do you understand that fully?
Yes, sir.
Okay, that's all. That was important. Now, looks like we're going to be moving on this case here. So, what was the offer in this thing?
Judge, we have extended an offer of 5 years in TDC
The minimum?
twice now. Yes, sir. The minimum. And he has
Okay.
credit for 635 days according to what we show.
Okay. Have y'all done the math in that? How that works?
He would be probably 6 months or less from parole eligibility.
If not now. If
It's
not
not
eligible now.
Yeah.
But, okay, that's, everybody makes their own choice. I just want you just have to know and make sure that you understand fully what you're looking at here, what the potential is. Nobody's talking you out of anything. This is your life, your choice. But they're offering you 5 years of confinement with credit for time served. And you know what the parole, this would be quarter time. I mean, he's eligible in a quarter of it.
Right.
And that's
It's not
one in a, yeah.
a deadly weapon, none of those things.
Yeah,
But,
so, and that's. If he's gotten credit, he's passed what he is parole eligible for.
Well, he'd still have to. pay-
It still is, the parole, it's all math. If it's a quarter of a time, and it's the parole authorities, but you are eligible for, you may be eligible for release very soon, if not immediately. But if we go to trial, I just wanted you to make sure this is your life. If you're found guilty, you're looking at a minimum of 25 years. All right. So do you understand where we are on this, sir?
Yes.
Okay. All right. This is your life. What is it you want to do here that you think is in your very best interest?
Trying to ask for something a little lower than that because he's in and out of the hospital.
Okay, that's y'all's business. That's not for me. They're offering,
They asked me today and 5 is the lowest I will
that's
absolutely.
what he's saying. That's the executive branch of government, not the judicial branch. He's the executive branch. That's what his recommendation is. That's what they're offering. It's up to y'all to either agree or not. But you gotta make it this time. It's the trial. I'm setting the trials and you're gonna be one. And they're going to, if it is not accepted, what are y'all asking? What are you gonna request the jury? You're seeking 25 to life.
Yes, sir. Yes, we intend to proceed on his
All right.
enhancements and
That's on the table.
25 is the minimum.
All right. There you go. What do you want to do? Yeah.
What?
I take the
Go. Yes.
See, I think you.
Write that up.
Fill out
That
the
please.
paper for the 5
Yeah, go over it with him.
Yes, sir.
So he's clear and he's making his choices freely
Yes, sir.
and voluntarily. Okay. All right, get that done so we can make sure that one is taken care of. Thank you.
So.
David, get that as soon as you can, please. Walter. Thank you. Then we go to, second was Senegal, and that was,
So that's good.
yeah. Okay, and then Chauncey Miller, we can't try that one, right?
Thanks, it's happy.
I don't think so, Judge.
Leo Cover is still on the table, right?
Yes, sir. That's the per se guy. So we still got issues with that, but yes.
Yeah, are y'all able to try it?
Yes, you're.
Okay, I'll leave it.
I'm not sure what he's gonna say as far as with Mr. Kimler was supposed to be a standby counsel and whether or not he got him.
Demanded per se,
And finally, literally everybody. Here's one out. One out.
Let's get Leo cover out then, Tommy.
I see two right there.
Yo, cover.
Yeah, Leo, Leo cover. He's some jelly ones.
That's all. The one that.
It's got two cases, right? Yeah.
Yes. That.
Hey, what? On Mr.
Yeah.
Leo cover.
Sir.
That's you, sir. Time's come here. I think we got you, ready, to go. We're gonna be picking a jury this afternoon. And as you know, you're charged with the state jail felony of, publishing or threatening to publish intimate visual matter in 2231. That's a state jail felony. And also in 23 CR 2232 is another state jail felony of theft of property. And each of these are alleged to have occurred on or about July 30th, 2023 in Jefferson County, Texas. And it looks like the victim is, or the complainant is the same person. And you're still insisting on representing yourself.
Yes, sir.
Okay, we're going to have a standby counsel to help you, John West. But you can take care of what you want to do on your own. You just have to, that's John, who's a competent lawyer. He's going to be there for you. If you ever need to ask him something, you don't have to. The law says they're in the bullpen, ready to come out to help you if you need it. This is your life. Yeah, bless you, you've made decisions here on how to represent yourself. And very seldom does this happen, that a defendant represents themselves, but it can under the law. And the important thing is that you're completely and totally appreciating and understanding that you're held accountable, like lawyers are, to know the rules of evidence, the code of criminal procedure, and the penal code. Those are the basic codification of laws that come into play in cases in this court, and these are where the crimes come out of. The penal code of criminal procedure dictates the way proceedings work through the process from the beginning to end, and then the rules of evidence or the methodology of how things are presented in court. I was on the Rules of Evidence Committee that wrote these, so I'm intimately familiar and sensitive about the way this is going to follow. What we're going to do is order a jury, and we will select a jury, voir dire the jury, and you're certainly going to have an opportunity after the state goes, I go first and do an overall, general, set of instructions. Then the state gets to ask questions of the jury, and then you can, if you want. And then that's all for the purposes of selecting a jury, deciding which strikes you're going to use. Then at the end of the voir dire, each party gets to select their juror, select their strikes and make their strikes. And then the first 12 jurors and alternates who have not been struck will be seated right over there. And then we will swear them in and begin the presentation of the evidence with the court's reading of the rules and the instructions to the jury. Then each party gets to make opening statements, and then the state calls witnesses. You get to cross-examine witnesses. At some point in time, the state will say they rest. At that time, you may or may not call witnesses. That's your call. You can take the stand as well. But at the end of the presentation of the evidence, I will read the jury charge. The parties will make the final arguments, and then jury will go back and deliberate on a verdict. Do you understand where we're going to proceed?
No, I don't, because I haven't been arraigned. This is my first time in court. I haven't asked if I'm guilty, I'm not guilty. I haven't been read the charges. I haven't had a motion hearing on any of my motions. I haven't had you ordered whether I could get subpoenas for my witnesses. I haven't had discovery, which I've asked for from you. I've filed with the court clerk. I've sent the assistant district attorney the letters for it. I filed for 2 writs of habeas corpus that hadn't been heard. I filed motions to quash the indictments that hadn't been heard. I got a motion right here to dismiss the prosecution that hadn't been heard.
You've never
You
seen.
haven't held any of my motions at all.
All right.
And here are the rules that you helped write.
Sir,
It says you should.
when I speak, you can stop.
Okay.
Because we can't speak over each other.
Sure. Thank you.
She's got to take everything down.
All right.
Follow those rules and don't be rude.
Okay.
Can you do that?
Yes.
All right. First thing, I thought we went over this indictment. You have, no judge has ever gone over this indictment, a JP or anybody else? Do you have a copy of the indictment?
No,
Of the
I don't.
indictments? You've never
I have
had a copy of the
It
indictment?
was on kiosk.
Okay.
It's on the
All
kiosk
right.
at the jail.
All right. 23 CR 2231 alleges that, in summary, that on or about July 30th, 2023 in Jefferson County, Texas, you committed the state jail felony of publishing or threatening to publish intimate visual matter. This states that with the intent to harm the complainant and without the effective consent of the complainant, you disclosed visual material, namely an electronic image depicting the complainant with her private portions exposed, and at the time of the disclosure, you knew or had reason to believe that it was created under circumstances in which the complainant had a reasonable expectation of privacy and that the visual matter would remain private. And the disclosure of the visual matter caused harm to the complainant, namely the image was posted on a public social media platform, and the disclosure of the visual material revealed the identity of the complainant, and namely that image revealed the face of the complainant and her name against the peace and dignity of the state, signed by the foreman of the grand jury. If convicted of this offense, you face no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand what you're charged with now in the punishment range?
Yes, I do.
In 23 CR 2232, this indictment handed up also on December 13th, 2023, goes on to allege that also on or about July 30th, 2023, in Jefferson County, Texas, you committed the state jail felony of theft. You unlawfully appropriated property, namely jewelry and clothes and tools, of a value of $2,500 or more, but less than $30,000 from the complainant, who is the same complainant as in the previous indictment we read with you, I read over with you. And she was the owner of that property, and without her effective consent of that owner and with the intent to deprive the owner of the property, you committed this theft against the peace and dignity of the state, signed by the foreman of the grand jury. As well, in this case, a state jail felony carries with it no less than 180 days up to 2 years in the state jail. A fine up to $10,000 can be assessed. Do you understand what you're charged with in that case?
Sure I do.
Okay. I thought Mr. Kimler was working with you before.
No, sir, and I don't know how Kimber ever got a retained lawyer, because I did not retain him.
Wait.
I've never signed anything to retain him,
Okay.
ever, never. My signature's nowhere. I've never retained him, I've never hired him. and I don't know how he got on my case.
What did he ever come to talk to you at all?
One time,
Sir?
one time.
Do you know how that happened?
Yeah, we have jail calls where defendants acknowledging Mr. Kimler, his attorney, he may not be very happy with him at the time, but he's on jail calls acknowledging that. I mean, he's up there sort of telling you this. Well,
thank you. He gets to speak. You don't interrupt, Mr. Interrupter.
now, I believe I think that was some of the confusion with the motions on it, because Mr. Kimler was representing the court, obviously is not going to respond to these motions when Mr. Kimler's representing him while he's doing it pro se. So then,
Yeah, I to this day, I don't understand. We've had this before, and I don't understand how that all happened, how that all occurred. Because read this. This is out of the file. Read that, sir.
It says, "Dear Judge Seasons, please be advised that I have been retained to represent the above referenced defendant on the docket cause number 7. Please set the case as soon as filed for docket. The defendant is requesting a speedy trial." And I see his signature. I didn't sign nothing.
Yeah, but it's signed.
He didn't ask me.
Thank you. But doesn't this purport to be something right, Kimler? You're
live.
Okay. Why do you think he would do that?
Sir, I don't know.
You never paid him any money, right?
No, he says he was retained.
I know, that's what it says.
He's
Lawyers,
retained.
look, I've known lawyers for 40 some odd years. They don't work for nothing.
I never.
Because it's their profession. I mean, they get paid one way or the other in some form or fashion. And some of them also donate their time, and that's what makes it a special profession, because they're helping other people, but they get paid for it, or else they're out on the streets poor and destitute. I mean, it's also on this same date. He requests a speedy trial. Just, that is the most bizarre thing. But you're not aware of anyone on your behalf maybe hiring him? Or
No, sir, nobody. I don't have anyone on my behalf but me. And if he's a retained lawyer, according to the law and the Constitution, I'm still able to file pro se.
And you're
limited if I have a court appointed lawyer, but not a retained attorney.
Mr. Adams has my computer right now, but I'd probably be able to find those jail calls pretty quick.
Of course, I said he was my attorney. That's what was on the record, but I didn't ask for him. Do you have a record with me signing for him? Sir?
No, sir. You just said
Okay.
just a second ago that you never thought that he was your attorney.
Exactly.
You never had. Now you just
No, I
changed your
said
mind.
he was not my attorney.
you knew he was involved in representing
And I've been
someone.
filing since last year to try to get him off of it too. The motions are all filed by the court clerk. And in those motions, I specifically say that I never retained him. And that goes back 13 months now.
November 13th.
The same as I haven't had discovery. 21 months, my first time in this courtroom for anything like this. Other than his motion to remove.
It's like I want them all.
Well, it's because someone purported to be your attorney is in charge of the representation of you according to them.
I've been set, reset
And
9 times.
once again, you're going to interrupt all day long.
I thought
Let me
you threw
speak,
them, sorry.
Mr. Rude. Once again, I
apologize.
used to get chastised in first grade. I learned.
Yep.
Okay, I have this attorney of record, Ryan Kimmer, back on 11/20 of 24 in this other case as well. And attorneys, when they purport to represent people, that's they're in charge of their representation, and that they got to be answerable for it. It just doesn't make any sense why this is happening in these cases. And of course, he's not around right now, so I can't really go into. Yeah, this one on 3/12 of 24, he requests a speedy trial in this other case as well. Which and it keeps getting resettings sent to him as your attorney. And Mr. Boyd is sending materials to the defendant, to Mr. Kimler purportedly. Yeah, I guess. And on 12/2, this was set on a writ hearing, and your attorney was Kimler was notified, and then also the state has filed a notice of intent to use at least 4 prior aggravated robbery convictions in your case. Which would that would enhance the punishment range from a state jail felony in each case to second degree.
Yes, Your Honor. I
felony
believe
punishment.
he's on parole for 120-year sentence right now or somewhere around that.
You know what? You'll get a chance, Mr. Interrupter, once again. Let him speak. You know what? You do it again, you prevent her from doing your job, and you get to get held in contempt of court. I've warned you enough. Let's not be rude.
Correct.
Okay, is he subject to an enhancement to second degree felony?
Yes, Your Honor.
I can't.
They are in sequence. There are at least 2 of those that are in sequence.
Okay. Okay. You understand? He's saying he wants to represent himself, which is fine. I'll have a standby counsel of Mr. West at trial. But can you get all this discovery over him as soon as possible?
Yes,
Can
Your
you do
Honor.
it in 48 hours or less?
Yes, sir. We can have him brought over and let him review all everything that we have.
Look, this is terrible because somebody was purporting to represent you, and they're supposed to be taking care of this for you. This doesn't make any sense. This doesn't make any sense. I've never seen this before pulled. And something is, I presume, a complete total misunderstanding, because I don't know, Mr. Kimber is not known to pull fraud at all. He's not a dishonest man. But this is bizarre that this has gone on this long purporting to represent you. I don't understand. And you've never seen him?
One time.
One time? But he purported to say he was representing you then, right?
No, sir.
What did you see?
It was about he come and see me about the blue one being lifted on parole. And the parole was,
Why would he do that for you for no particular reason?
I don't know, somebody asked him, I guess. But it wasn't me. And parole is the whole thing behind this, just like he keeps mentioning parole. He's more concerned about my parole being broke than any evidence. There is no evidence.
No, he's not. He doesn't have a say in the parole, so he's concerned, like they all are, about doing their job that's relevant in this case. And parole is not the point. Parole, felony, final prior convictions are the point. It's the circumstances of the crime and criminal history. That's relevant.
Yes.
Don't say it's not. It is. Get that to him. This has gotten now. I'm concerned because I want him back in a week to make sure that he's got it all and he's had a chance to look at it, and because we're gonna get this thing to trial as soon as you've been languishing too long.
So can I have a question, please?
Yes, sir. Go
Are
ahead.
we gonna have a pre-trial hearing on my motions?
Yeah, we'll do that.
Fantastic.
Yeah, we'll do that. And we'll come back in a couple of weeks. Okay. We'll set it for then. Yeah, to give them time to get together. All right, that's.
The hearings are March 31st with right, if I can find it, you get released right.
This
For the
year.
record.
Well, I think it was, we were here at a hearing before.
Well, right.
Yeah, and that's when he was released, but I think you insisted that.
Yeah.
Absolutely.
Yeah. And we went over the importance of understanding and appreciating self-representation, because that's what I would do in these cases. And just keep, anytime you want to get someone to help you, but they will stand by and be available. And it's John West, that man right over there. He'll introduce himself to you, and you can ask him any questions that you need right now if you wish. Okay, so his is reset for 2 weeks.
Yes, sir.
And it's got my foremost attention out of the 2,500 cases I've got. This one's gonna fast track and make sure that you're ready and get this, we'll get this done.
2 weeks for pre-trial motion.
Pre-trial, yeah, we'll do pre-trial and thereafter we'll set it for trial. Okay, all right, that's all, sir. Thank you. What does that leave us, gentlemen and ladies?
Is that a real reason?
On Chauncey Miller, but did Langston say he's available or not?
Langston just went back there, I think, to talk to him again.
He's showing the video, Your Honor. I think he's trying to get it resolved.
We've got paperwork for.
Okay, can we get Langston out for just a second?
Do you want to do that paperwork for Joshua Goth?
Yeah.
Or Goff?
What's going on?
Yeah, David's got something with Goth.
Yes.
Mr. Goth?
Or Goff?
It is there. Very.
I'm over here, I will give you some trust here.
Okay, your time just.
Not back there.
All right. Danny, what do you hear?
Laundry. Jimmy Hill. Burge.
I don't remember. Second you?
I have a plea for Mitchell Sylvester,
Okay.
and if that thing is usually.
I've got. Did I give you back Mitchell Sylvester?
And you did, sir. It's right up.
Okay. Take this plea. 25 CR 307. Mitchell Sylvester, please.
Didn't know if you wanted to take Mr. Groves first. Either way.
Get this way and then take Vegas funds.
Same funding, we're down there on the line.
Oh, look at mine, but my bad. Yeah. Twenty-five CR 307 is called the State of Texas versus Mitchell Sylvester. That's you, sir? You're Mr. Joseph Sylvester with Ms. Manaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary here?
Yes.
In summary, this indictment, are we only going on paragraph one?
Yes.
Yes,
He's a habitual felon. Okay. Paragraph one alleges that on or about February 16th, 2025 in Jefferson County, Texas, you committed the first degree felony of aggravated robbery. Do you understand, sir, what you were charged with?
Yes.
If convicted, you face no less than 5 nor more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000 can be assessed. Do you understand the punishment range that you are facing here, Mr. Sylvester? An agreement has been reached in your case. You would be pleading guilty, sentenced to 20 years in prison. Is that your understanding of the agreement?
Well,
Is that right?
yeah.
Is that right, sir? You have to speak out. Okay. If I follow this agreement, sir, you have no right of appeal of your case. Do you understand? How do you plead to this charge in this indictment? Guilty or not guilty?
I'm guilty,
Okay.
but I don't have no indictment.
Okay. This indictment again states in summary here that on or about February 16th, 2025 in Jefferson County, Texas, you committed the first degree felony of aggravated robbery with the use or exhibition of a deadly weapon, namely a machete. Do you understand what you're charged with here, sir? Yes.
Yes.
Okay. And how do you plead to this, sir? Guilty or not guilty?
I'm guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
That's it.
I'm going to show you what's marked here as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney, Ms. Manaldi here. Is everything true and correct?
Yes.
State's Exhibit 1 is tendered into evidence without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer, Ms. Manaldi. All of this is true as states, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived?
Yes, sir.
I will follow this agreement, sir. If nothing further, I am going to find then that you are pleading guilty to this indictment voluntarily. You are mentally competent to do so. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this first degree felony of aggravated robbery as alleged in paragraph 1 of this indictment. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a machete, was used in the commission of this offense. And Mr. Sylvester, do you understand what has happened today, sir? You will be given credit, by the way, for all time you have served in accordance with this case.
Yes.
Oh, thank you. Good luck, sir. David, you're up. Keep that up. Who is this?
This is
Try two more.
Mr. Johnson?
God.
Okay, yeah, that's right, Joshua.
One more.
Bob.
I keep saying go for them.
Go say, well, I think the same thing, Judge, because I had another fellow, his name was Gothay. So I get him confused.
43 CR 1455 is now called.
Stand by.
The state of Texas versus Joshua Ray Goff. Present with Mr. Grove, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
And it's just paragraph 1.
Yes, sir.
Paragraph 1 alleges that on or about July 3rd, 2023 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with, sir?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty, sentenced to 5 years in prison. Is that your and they're only going to proceed on paragraph 1. So you weren't facing, it looks like, up to 20 years in prison. So you would be confined for 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Guilty, sir.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it?
Yeah.
Discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without
No
objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial, rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is a pre-sentence report. We're hereby waived.
Yes, sir.
I'm going to follow this agreement, if nothing further, and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty of this third-degree felony of evading arrest and detention with a motor vehicle. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years confinement. You will be given credit for all time you have served in accordance with this case. Do you understand, sir, what has happened today?
Yes, sir.
Okay. Good luck to you, sir.
Yeah, thank you.
5 years. Who's next?
I'm not sure, but the last one on the trial docket, Your Honor, Miller, he's going to plea. Mr. Adams is signing him up right now.
Chauncey? Okay.
Urge was no other big thing. I don't believe Mr. West had it. It is. Yeah.
All right, right, that just took care of the trial docket, correct?
Looks like Senegal. Senegal looks like the only one left.
Yes, Senegal.
Mr. Senegal?
I don't think we told. Joe, if you ask. Everyone talking our letters.
Okay.
Are you getting ready or not? I'm getting ready.
What's just that?
Okay, here's. Jason Murchison.
That was Nathan Reynolds. You said trial and all 5. He was on the judge.
Yeah.
Going down here.
Then I've got Senegal. Got Anisha Hawkins.
I think that was. Hawkins was. 5 years. 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 5
Mike had a, we need a special set on Hawkins?
Yes, doctors for shaker baby.
We know.
I do not just set it sometimes so I can give them enough notice.
So we're talking about Mendez,
No, that's Hawkins.
Quenisha Hawkins.
Kenesha Hawkins, two cases, 23-41581 and 41582. That is reset to when?
Whenever, I just gotta give the doctors enough notice to where they can.
Is 4 weeks good?
Make it 6, please.
Sorry,
6 weeks, please.
6 weeks.
Yes, sir. I'm
Done.
sending the letter out today.
Reset then, Joshua Mendez. These two cases,
You reset that, because of my DNA issue.
already did that, right?
Yes, sir.
Trevante Nichols, 3 cases.
Let Mr. Lewis reset that. It's a quick one. He's gonna,
So
we just
quick
got new
resetting.
phone records on.
Jonathan Cruz,
That was reset with Wilkerson for me to look at some new evidence they want to give me.
okay, and then I've got Chauncey Miller here that's working. Okay. What else did I have on?
Brian said they've been waiting for you to do that one, and then we've got some other inmates, jail docket.
Yeah, it's,
I know,
okay, we don't have a trial then, right?
I think we've pled, well.
What?
Right, I think the trial hasn't been resolved, Gunnar.
Trial that's been resolved.
You must just come back after lunch for the rest of the jail stuff.
Yeah, yeah, it's 12:30. I mean, I've still got some stuff left. But we had a bond case too, right? Bond matter. How long is? Okay. How long will this take? Do y'all want to go forward now or wait until come back?
Can, everybody's here, Judge, but
All right,
it's not. It's not
Let's take-
lengthy, it's one witness.
let's take that up. When we get Chauncey Miller though ready, we'll plead that one, okay? Thank you. Okay. Bathroom.
Like, so what are they so much?
And Joe, we're making Joe come back at one, right? We didn't do Senegal. I mean, Mike asked for.
Yeah, yeah, yeah.
Senegal, we didn't want to release that.
No, don't want one because he wanted to get off the case because the guy filed a grievance on it.
Oh, that was the grievance.
Yeah.
I was
Second.
like, okay.
Okay, Trevor Burge.
That's what we're doing. We're not going on. Okay, we'll see. I got people coming if we have.
Okay.
Oh, it's still up in the air whether I'm going or not. We'll see. Fine. He's very careful. Basically stop.
Okay, we call 22-40978, the state of Texas versus Trevor Burge. You, or Mr. Burge. In that case also, there is, that is a motion to revoke unadjudicated probation. And there's a new indictment that's handed up as of April 16th, 2025, third-degree felony of assault family member and stand by.
I'll go get some.
So you were on probation as of September 14th, 2023 and 40978 for assault, family violence, choking, and the complainant in that case is a member of your and then now there is a new indictment that's been handed up as of 4/16, which alleges on March 13th on or about March 13th, 2025, that you committed the third-degree felony of assault on the same complainant that you were placed on probation for in a Class A misdemeanor assault. Do you understand what you're charged with? Oh, sorry. I was rolling on. In 22-40978, there is a motion to revoke unadjudicated probation that states that on September 14th, 2023, in this court, you were placed on 2 years deferred or unadjudicated probation for assault causing bodily injury to the complainant in that case, and was a family member. Thereafter, you were placed on probation. The motion to revoke probation was filed in that case. The new indictment, 25 CR 430, handed up on April 16th of 2025, alleges that on or about March 13th, 2025, which would have been like a year and a half after you were placed on probation in 40978, it is alleged that you committed assault, family violence on the same complainant that you were placed on probation by kicking the complainant. And that is a third-degree felony, which carries with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Does everybody understand? Do you understand? Okay, you may be seated. Go ahead.
I want to give kind of an opening remark to the court, and then I'm going to call a witness in support. I would point out to the court that we're dealing with a motion to increase bail as the call number 25 DCCR 0430. And then actually a second motion to increase his bail in regards to cause number 2240978. That's the one that he's on probation. So the reason why I bring that up as a remark, Judge, is you've already cautioned this man, I don't know how many times, about to have any contact. So it's an oddity to begin with that we even file a motion to increase. It's the only time I've ever filed a second motion. So in that regard, I would call Erica Birch.
Report, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Please lower your hand. Thank you, ma'am.
Can you say your name for the record, please?
Erica Birch.
And are you the named victim in call number 2240978?
That's correct.
And are you also the named victim in 25 DCCR 0430? Are you aware of the bond conditions that Mr. Burge is not to have any contact with you?
I am.
And in fact, when he was in custody, prior to making the initial bond, did we have issues about him making contact with you then? Did we raise those issues before the judge actually set a bond on his motion to revoke probation? And are you the same person that he had indirect communications with that resulted in the first motion to increase his bail?
Yes.
That was contact with his mom, wasn't it? Yes, excuse me, your mom. And since then, has he had contact with you again? What is the nature of that contact? In addition to that phone call, was there other contact? All right, so that's what we're going to be dealing with here today, correct? Have you reviewed the phone calls that you received? May I approach you?
Yes.
Show you what's marked as State's Exhibit 1. Are these contained the 2 phone calls that you received?
Correct.
When did you receive them?
on Father's Day, evening, and a day later.
Do those phone calls true?
Which year? Father's Day when? Oh, just recently?
Yes, sir.
Okay.
So we're, obviously, we're talking about stuff that's happened very recently.
Very recently.
So this Father's Day,
Correct.
2025, this is June 15th.
Correct.
Right, so for the purpose of these phone calls, can you identify all the voices that are heard in the phone calls?
Correct.
Do the recordings truly and accurately depict the entirety of the two phone calls that we're concerned here?
Yes.
And can you represent to the court that all of it has are true and accurate recordings, meaning nobody's deleted, added, or taken anything away from the original report, other than just duplicated? Right. With tender states exhibit 1, I'll tell the court for the record, I've allowed counsel to listen to those items.
Your Honor, we do have an objection because there is some clicking noises on the recording, and we are concerned that it may have been altered. And unless they can show the device, because from what we've been told, it's recording of a recording. It's recording of telephone conversations. We're objecting that it comes into evidence because we have concerns that it may have been altered.
Who's doing the recording?
She's doing the recording.
Okay.
And it's on her phone, and I was getting to listen, I can listen a little bit more.
All right. Anything else?
Your Honor, we just have concerns that they may have been spliced together. They're different clicking noises.
Objection overruled. It is admitted. Go ahead.
All right, so-
Have a fair opportunity to cross-examine so the court can make the test on how much weight and credibility to give to it. Go ahead.
All right, so before I play it, the judge has admitted it. This is your cell phone that you're receiving these phone calls on? How long have you had that number?
10 years.
And so because it's relevant to the hearing, what do you do for a living?
I'm a bondsman.
And do you take phone calls at all hours of the day?
All hours, 24 hours a day.
Does it matter if the call says spam risk or not?
It does not matter.
And why do you do that?
That's our clients. The court knows calls from all different apps. They're regular phone companies. They tend to not keep a phone number. They use Wi-Fi numbers.
So that's why you answer all calls,
That's
right?
why I answer all calls.
So these particular calls that we're about to play for the judge, did they show up as coming from Trevor Burge?
They did not
How did they appear when you received these calls?
scam.
And were there other numbers that you didn't identify, or were they all initially as spam?
They were never good at identifying as spam.
Okay. So that's why you answered. Did you recognize his voice? Do you have any doubt in your mind that it's Trevor that made these phone calls? Did you identify him actually during the conversations?
Yes, I did.
Did you tell him not to? Had his name appeared, would you have taken the phone call? Yeah, publish it to the board, yes. Birch, do you remember about what time you received this initial call?
10/11.
What time? AM, PM, PM, okay.
Okay. With Alan.
Hello. Is something wrong, Trevor? Why are you calling? Because we're Trevor.
So Ms. Burge, I paused it there. First, tell the judge why you're actually videoing the call instead of recording.
I videoed the calls because Mr. Burge proceeded to call 2 times prior to that. And when on your iPhone, if you click to record the phone call, it notifies both parties. So when it notified both parties, meaning I, Mr. Burge, he would hang up.
We knew that would take place. So we paused it here. Do you recognize that number that's on the screen?
I do not.
Is that attributed to anybody that you know?
No, sir.
Is that one of the reasons why you took that video?
That is correct.
I don't know.
Stop calling us. What? What?
Oh,
Talk about what? There's nothing to talk about. Stop.
oh,
Stop, Trevor. Stop.
I'm sorry.
You're not. Stop.
In that phone call, he refers to you as mom.
Correct.
Is that something he called you? And you've known this man for how long?
Over 9 years.
You would recognize his voice,
I would.
I'm assuming.
That is correct.
Any doubt that that's him on that call?
That is.
Is that the end of that particular phone call?
That is.
Did he call back?
He did.
And is that the second phone call that we have?
That is correct.
And again, so the record is clear, what day is this?
I can't hear. I can't hear her. Go in. What was the date, man?
The same night on Father's Day, 2025.
So when he calls back, is it a different number?
It is a different number.
Does he immediately jump into a conversation?
He does.
And are you able to do like what you did with the other call, video recording?
That is correct.
This appears to be a little bit shorter, about 21 seconds, right?
Correct.
There we go.
Father's Day, Mom, please.
Girl, you're not supposed to be calling. Why are you calling?
Because I can't take this no more. It's Father's Day, Mom.
You chose this. You chose this. Leave us alone.
I did, you know.
Right at the beginning, Ms. Burge, it appears that he says something, and it sounded to me, and you correct me, it sounded to me like he admitted he knows he's risking it all.
That is correct.
I'm gonna play it again to see, make sure that you hear it. And again, this is a different number that's appearing up on the screen, correct?
Correct.
Father's Day, Mom, please. I'm risking a lot.
It's words where I'm risking a lot.
Yes.
And again, any doubt that it's Mr. Burge that's contacted you?
None at all.
Ms. Burge, you've not actually been present for all those things that I was summarizing for the judge, but you've watched it on YouTube, haven't you?
Religiously.
You've heard the judge caution him on every appearance that he's not to have any contact with you.
On multiple times.
You've also heard the claim when I tendered that they think that you may have spliced this. Do you have the ability to do that?
I do not.
Do you have any interest in doing that?
None at all.
You want them just to leave you alone?
Just.
May I approach the witness?
Yes.
After these phone calls, did you in fact receive what I've got as one item, states exhibit 2? three different things on an app on your phone.
Correct.
What is the app that he was contacting you on?
YouVersion,
What is that?
a Bible app.
For the purposes of reading Bible plans?
Correct.
Was he a friend of yours on that particular app?
He was.
And was that the same night?
No,
So what day did this happen?
June 16th of 2025.
All right, so June 15th was when you got the phone calls. June 16th would have been a week ago in history,
Correct.
last Monday, yes?
Yes,
You send your friend request?
yes,
Did he ask you to read two different Bible plans?
he did.
Are those documents represented here by the items that we've gotten the judge's review and state's exhibit 2?
Correct.
Or you reviewed these items upstairs as well, that's correct?
Uh-huh.
Do they truly and accurately depict what you received through that app, the generated information that occurs there?
Yes, sir.
Does it in fact have on its face your email, the date for those items, yes?
Yes,
Did you give him authority to contact you in this fashion?
I haven't.
Did you find that contact harassing? State's Exhibit 2, Standard Counsel for Objections.
Yes,
This is the first time I've seen it, Your Honor, so I got it. Your Honor, I have objections to this under best evidence review, best evidence. It doesn't show it's actually from the app. It looks like it's an email from the app, so it looks like there's hearsay in it. There's also best evidence because they're not producing the actual app itself. It's something else other than the app.
Response? State.
No, I can tell you that the app generates that. This is the best way to document for any appearance in court that this is done. So I would say this is probably, following her objection, is the best evidence. The bulk of the information that the court needs here is the defendant's name, as well as a picture that purports to be Mr. Burge that generates all this.
Your Honor, I'm still stating best evidence. They can bring the actual app in here, and also with anything with social media, the court I'm sure is aware it can be spam. People can spoof it. They can say it comes from someone's account and someone else can create it with your likeness with email. So I'm still saying best evidence. I would like more information from YouVersion as to how we need someone from there that can actually testify as to how they send out app notices, how they do all of that, rather than this email, which is not best evidence. And also it doesn't have, with anyone, I could create a Facebook account today as you, Your Honor, put your likeness on it and your email, and I can send it to other people. That can be done.
It just goes to the weight and cross-examination, not the tender of the evidence, Judge.
All right, let me see that.
Yes, sir.
Okay, Stacy, number 2, can you just summarize through this witness what this witness knows about that exhibit?
All right, so how was this generated, Ms. Burge? How did you generate these documents?
my email.
And is that the email that appears here, the two?
Correct.
So walk us through what you did to generate this.
I received a notification in my email address that Mr. Bird has been sending me invitations to those particular, to this particular reading.
So that's a notification process through the app.
That is a notification process, correct?
So when you clicked on it, is this what appeared?
That is correct.
And it gave you this, the email itself that generated was this information
Correct.
in its entirety.
Yes,
You didn't add or delete anything else as far as that's
I did not.
concerned. You may have printed that stuff out.
Yeah.
And you actually provided all this to not only me, but law enforcement in regards to the protective order violations, correct?
I did.
You didn't, or did you add his picture?
I did not.
Is that something that came with that notification email?
That is correct.
So this is just merely printing out that email.
Correct.
Is that what it says on there that you can unsubscribe?
That is correct.
So one of the options that you have with your app is whether or not you receive these notifications.
That's correct.
Then did every retailer state to do it too.
Anything else?
Your Honor, we are still objecting on the fact that someone can create another account and send email to show that it was my client. I don't think that they've shown that that is him.
Overruled, it is admitted.
Just so these states too, Judge.
It's admitted.
Last one.
Hello, Ms. Burge. Hello. Isn't it true you have a pending family law case going on? And isn't it true that your family law attorney, Ms. Diamond Beckham, is in the courtroom today?
Yeah.
Is it correct that your family law attorney, Ms. Diamond Beckham, is sitting in the jury box close to you there on the witness stand? Yes. Isn't it correct that you just talked about you videotaped the phone call, is that correct? Sure. And there was clicking noise on that first phone call that was played. Did you hear that? I did not hear any clicking. And I'm sure you're aware that with artificial intelligence, you can recreate someone's voice. Are you aware of that?
I did not recreate anyone's voice.
And I'm sure you're also aware of the Office of the Ombudsman that, or even a person, that anyone can go into a Facebook account, any social media account, and create an account saying that there's somebody and it's not them.
Correct.
I'm sure even like a grandma can tell you that that's happened to them. Am I correct? Possibly. And you want my client to be in trouble, don't you?
I do not.
You're upset with them. Is
I
that
want him to follow the rules.
And isn't it correct that on this, you had the phone call, but you did not produce any of the metadata for your actual phone calls, is that correct?
It is not.
And the metadata, Ms. Burge, that would show us when the actual phone call was made and other information to be set to you.
Possibly, I'm not sure when the outset of them.
And you did not bring anything else with you today, did you?
I did not.
Your Honor, we have nothing further to consider.
Ask that you be allowed to sit down, just
Okay, you are excused, ma'am. Next, please.
stay rest.
What says defense?
Your Honor, we rest.
Okay, summary, state.
Like I said in my opening, Judge, I've never had to file a second motion to increase. I recognize the man's voice. I've heard him talk many times. He's not following any rules. Contacted her when he was in jail before you let him out. On the MTRP, we were prepared to prove that. He sidestepped that issue and Counsel Crenshaw got him a bond set and he was released. After that, despite your admonishment report, He then tries indirect contacts with this complainant. And he showed then that he wasn't going to follow your rules. We had to bring him back in. You admonished him again. And here we are. That was after we appeared, maybe less than a week from when this occurred, when I was pushing to have a hearing in this matter. And the end result is, here we go. Now we're set for an MTRP hearing on this on July 11th. I am genuinely concerned for my client's safety. I did not have her testify today about the efforts that she's gone to ensure her safety, but this man has nothing to lose. He said it himself in his own words. This Miss Burge has left her house where she should be safe so that Mr. Burge would not know where she's at. I'm asking that you do what you've said before in court, Judge, whenever people routinely will not follow your court orders, and that is to increase his bonds. And I would even suggest that it should be a no bond.
Your Honor, we're asking that the court look at the evidence before it and recognize that evidence can be altered. And with the way technology is today, you do not have to be an expert. You can splice together voices to create whatever you want them to say. We're also asking that the court take notice of how Facebook accounts, social media accounts can be altered. Anyone can go and say there's somebody else when they're not. And what we're asking is that the court take notice of this. And we're just asking that Mr. Burge be allowed to still work, provide for his family until the court's able to hear the evidence that's produced at the motion for revoke probation hearing and the actual trial for the new case.
What is bond, his bail, but his bond?
Judge, can I make a brief statement and give you some procedural history in the
I
family?
don't-
Your Honor, we
That's
object-
just kind of
object.
out of a,
Yeah,
you can't just blurt that out. I mean, if you want to go, if one of the parties wants to present that, but Ms.
Oh.
Beckham, you're not in this game right now.
I understand.
The only
That,
thing that may be relevant of that is he was given similar admonishments in the family court underneath his restraining orders and all that.
In the protective order.
And the protective order that exists there as well. I will inform the court additionally that New Orleans Police Department is talking with me this morning. Charges are coming as to the violation of protective order as well.
okay. That. Until the charges come,
Yeah.
we're.
I'm just being an officer.
Presumption of innocence.
Yes, sir.
Kind of is important. It's only
Yes, sir.
dates back to the Magna Carta.
You've heard the vast majority of what that case entails. Anyway.
Yes, sir. What is his bond, please?
10,000 plus stipulations, I believe. 10,000 plus GPS, no contact with victim in the case for judge. April 2nd.
And which
Based on
number?
That day,
Which number?
in the 2249.
Well, the MTRP is pending. What was the date? Please.
4-2.
Okay.
He may bond on that one. The second one was 4-17.
What was this? What was 417?
$20,000.
No. What?
The one on fourth, the one in 25 DCCR is 20,000 plus the.
Is that 430?
Yeah.
You need? Okay. Give me that again. That's
20,000. But no contact. That was 417.
the MPRP again. Is how much?
10,000 plus GPS.
All right. Here's what the court's going to do. The court is, to say the least, concerned and disappointed. I was real clear on what your requirements were. And until we get all this sorted out, what has gone on here in this turning to a bizarre situation, you have a motion to revoke unadjudicated probation that was filed as of March 24th of this year. And on or about March 13th, this new indictment filed on April 16th, 2025 in 25 CR 430 alleges a disturbing indictment of assault. And the first case, 40978, is choking, assault by choking, a third-degree felony. Then we have another third-degree felony where it is alleged that you caused bodily injury by kicking the complainant. Nonetheless, it's very disturbing when family unit is assaults on the family unit occur within family members. And that's what the grand jury in each case has alleged you have done. Now, I ordered absolutely no contact, and there's a good reason. We try to separate, get to cooler heads, try to work things out, because this court is a pro-family oriented kind of person. I believe in that. I believe in the strength of the family and all the assets that come with the family unit. You people who work against and work toward a division of a family, that's not a good thing. It's bad. And that's why this court has ordered you to have no contact. I find clear and convincing showing me that this is you on the phone. And there's absolutely nothing that has indicated or hinted that this is anything that's been contrived in any way, shape, or form. And I've heard you speak. I recognize your voice. What's the state asking for?
I'm asking that there be no bond, Judge, and it's just repeated violations.
You have been accused of, in two separate cases, assaulting the complainant here. And when you violate the court's orders of contact, it's you can sense, I can sense the concern. It's just violating her again. And it's very weird because it almost sounds like you might have been intoxicated or something. It's late at night and you're speaking in kind of a halting voice. I don't know, but the fact is you're caught communicating with her when this court's order said otherwise. Your bonds are revoked in each case. No bond is allowed. You're taken into custody for violating these bond conditions. They were clear, crystal clear. And the victims, the complainants who are victims in cases aren't going to continue to be re-victimized on my watch while this case is pending, or any case is pending. I will take action. You've been forewarned. You have crossed the line. You will stay in jail until we can resolve these matters. When can we get this motion heard, please?
There's a current setting of July 11th, Judge.
When do we want to set the trial for 430?
That's waiting for whenever they want to.
All right, I want an announcement on that in on the date that we had this motion to revoke probation hearing. Anything else?
No, yeah,
That is, we're recessed on this case. Thank you. That is all. All right, I've got something, Langston. Let's complete this. Who is it? Okay. You have that file? Have a chance.
I don't have that.
Ben got it to me.
I see it.
I'm chancing them.
It was the only one that was still green.
Okay. I don't have the file though.
You sure?
Yeah. Well, I have Senegal. It's the only file I've got. Hold on. Never mind. It was under Senegal.
Okay.
What are we doing in Senegal?
Joe, I think just we made Joe come back.
Where's Joe?
It was the only one that
I
was
know.
left on the.
Oh, are we gonna have a trial, Joe, or not?
This is the one you're.
Are we gonna have a trial or not?
I
What do you
think
think?
so, Your Honor, unless you let me off the case. This is the one where I filed a motion withdrawal. And you were thinking about it, I guess.
Okay, I bring the guy out again. On Chauncey Miller, we're coming out with that.
I didn't mean you guess. I meant the court was considering, you know.
Listen, there's nothing we can do today. I mean, we've only been working for 6 hours. Straight. I mean, we're not getting anywhere on this. We're gonna have to have everybody come back tomorrow, I guess. On Chauncey Miller?
Miller?
Yes, ma'am. Thank you.
Yes.
Come on up, sir. Does he need to be French first?
No.
No, I got it out.
Okay, Chauncey Miller?
Yeah.
That yours, sir? Okay, 24 CR 832 is now called. And you were here with Mr. Adams, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this states that on or about March 8th, 2024 in Jefferson County, Texas, you committed a second-degree felony of assault on a peace officer. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 5 years in prison, and given credit for all time served. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is, hold on, that is on your own free will and because you are guilty.
Correct.
All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. And this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of a crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Correct.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
If nothing further, I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. Do you understand what has happened today, sir?
Yes, sir.
All right. Good luck to you. No more fighting.
Thank you, Your Honor.
Okay. Thank you. And here. Finally, can you get me Xavier Senegal one more time, please?
Yeah, he wasn't here when we talked about it this morning, so he hasn't been in front of you today.
Mr. Senegal, hey, here, how are you?
How are you, sir?
As you know, you are charged here in this 22-40440 indictment, the third-degree felony of stalking. It is a third-degree felony, which carries with it up to 10 years in prison. Your indictment also states that you were convicted in 2016 in the court next door as of 2 offenses, burglary of a habitation, and also felony of
Failure to register.
let me do the speaking, yes, failing to register as a sex offender. So that punishment range, that third-degree felony, if all of that was true, would be enhanced or increased to second-degree felony punishment, so that you are looking at up to 20 years in prison. Do you understand all
Yes,
this?
sir.
Okay. Mr. Vasquez has been appointed to represent you, as you know, and here's where we are. This is the last case left, and the jury is outside, and we're going to bring them in and pick a jury here. Y'all ready to go?
I am, Judge.
All right, Stace ready? Y'all ready?
Yes, sir.
All right, we're going to try this.
Just need to make it clear on the record, Judge, that the offer was 4 years, that once I stand up and start board hour in a minute, that offer goes away and there'll be no more offers. So that's.
Also, do you understand, sir, as well? And I'm sure you've been told this, if because of your felony convictions, you are not eligible for probation if you're found guilty.
Yes, sir.
You understand that? Did you need to talk to him any further on any of this
Yes, sir. Yes, sir.
right now?
Yes, sir.
Yeah, go ahead. Talk to him. Yes.
Thank you. Don.